You guys are working now? You guys are working last week?
I don't think so.
I don't know how important exactly report. It's mine written brown.
Just take a seat now.
That's your first motivation. Don't worry about the first row. Excuse me.
Morning. All right, everyone. Good morning. It's Monday. They tell me it's dense fog outside. It looks sort of like London weather. It's very foggy with a slight chance of rain. We'll see what happens. All right, I'm going to call the docket. When I call the docket, please let me know you're here. If I don't know you're here, a warrant may be issued for your arrest, and then it's going to turn out to be a bad Monday for you. So let's keep it a happy Monday. Brianna Kelly. Brianna Kelly. Did somebody say Brianna Kelly? All right. Yeah, don't sit on the front row. Jalen Collins is in custody. Santuan Wilson. Santuan Wilson. Janelius Cruz in custody. Jose Lozano. Jose Lozano. Israel Elizondo. Joseph Garza. Joseph Garza. Gaydon Cantu. Scott Marcelino. Thank you. Ronald Collins. Ronald Collins. Renee Cantu. Renee Cantu. Joe Anthony Jimenez. Joe Anthony Jimenez. Juan Pablo Aveles. Samuel Rodriguez is in custody. Lindsay Pierce. Lindsay Pierce. Jalen Collins. Tremonte Singleton. Bernardo Huerta, custody. Corbin Patswa. Corbin Patswa. Donald Davis. Donald Lee Burnett. In custody, we have Sergio Garcia. Lisa Marie Garza. Thank you. In custody, we have Jerron Crawford. Antonio. Help me with this, Deputy Laura. Antonio. All right. Alejandro Trevino. Steve Terrazas. Steve Terrazas. Mark Anthony Pena. Ronald Mendoza Orta. Yes.
That's taken shortly, Judge. I'll let you know when you're out.
All right. Diamond Danzy. Anthony Cruz.
Here.
Brittany Brown.
President.
Jose Gallegos. Jose Gallegos. Lindsay Pierce. Mario Carranza. Thank you. Roland Garza is in custody. Hector Lopez Nahara. Jacob Moya is in custody. Roland Lopez. Christopher Armstrong. All right, anyone came in late or your name was not called? Yes, what's your name? Do you know who your attorney is? Okay. Have you had contact with your attorney?
Yes.
All right, just have a seat. We'll get to you. Yes,
Aaron Rodriguez.
you say Aaron Rodriguez? Who's your attorney?
Torres.
Who?
Torres. Rick Torres.
All right, so everyone, these cases are probably some of the most important things of your lives. You should probably remember your attorney's name. Yes, you need to put that phone down, sir. Yes, who are you? What's your name?
Yeah, Carlos.
First name?
Carlos. Carlos, yeah.
Do you know who your attorney is?
Come on. Come on.
Everyone who's coming in late, who's creeping in late, y'all need to creep to the front row because you're late. All right, anyone else who came in late? All right, we got Mr. Wilson. All right, and you're always dressed appropriately for court. I appreciate that, but you're late today. That's okay. Who's next? Jesse, what's the last name? All right, do you know who your attorney is? All right, and your name? All right, just have a seat. Anyone else who came in late? All right, these are the rules of court. I try to keep the center of the courtroom as least congested as possible. Attorneys, if you'll just grab your file and place it on the prosecutor's table, they will call you in the order in which they received the file. Once you place your file on the table, just have a seat. They'll call you up. Do not approach the court if you have not conferred with the state and have not conferred with your client. If your client is in custody, let the deputies know. The deputies will bring your client out. Do not leave once you requested your client. If your client is a Spanish speaker or speaks a different language and needs an interpreter, do not leave. Have the interpreter called down. There's a shortage of interpreters. So once you've asked for your interpreter, do not leave. And even if you speak your client's language, I still want an interpreter here. So everyone, today is Monday. I'm sure many of us thought we would be retired. We're not retired, so we're just going to have to embrace that. And let's make today a good day. Put some patience in your pocket. Please confer. Deputy Laura, he's going to need his client, Christopher Armstrong. Good morning. Okay, great, thank you. The defense attorney, what's the defense attorney's name? All right, we need to call him and have him. Okay. All right, so we're gonna get him called, we'll get Kurt Hockty here as soon as possible. Thank you.
No problem with my guy?
Yes,
On this one?
this one is. This one, for some reason, it took a long time.
Anyway.
Can we call it connection, back in our group? I want to correct what you're doing now.
Okay,
Can I come back during lunch?
Yes.
And take care of it?
yes.
It might be doing this for a little bit, if it really gets where it's real bad, or it goes up for, for a long time, give me a call back.
All right.
I'll take a look at it. I don't want to interrupt.
All right, thank you. You know, it's going to be a great day when we have to call court pet. That means it's going to be a beautiful Monday. Robert Bauer, good morning to you.
It started off kind of dicey.
Yeah. But that's the best type of Mondays, when it's a little bit dicey.
your laptop on for lunch?
Yes.
Needed to have the signature.
Yes, I will. Who's here? Lisa Marie Garza.
And she's present as well. Lisa,
Ms. Garza, if you'll come forward.
how are we oriented?
Oh, you're there and she's in the center. Robert, what happened?
I had skin cancer removed on Friday
Oh, my gosh.
and it got infected.
Oh,
So I sent my doctor said, you can send me a picture, but I sent it this morning. He's like, and I got a call, not from him, but from his office. And yeah, the doctor said to give you an antibiotic. I'm like, he didn't tell me that. No, you need one.
yeah. Oh, my gosh.
Right.
Yeah. Okay, so what we're here for today is discovery. Do you have all the discovery?
Oh, ma'am, and I talked to Jason. There's some other stuff that he's going to have to look for. There's notations about surveillance footage and also some previous reports that were not included. I think he's going to have to contact the detective.
All right, could everyone please whisper? Jason?
This Jason.
Oh, this Jason. Hi.
J2. That's how I'm
Okay.
going to designate it now.
Well, see, but then you'll be saying 2.0. And is there really a 2.0 of Jason Garhan? I don't think so.
JJ.
My mom would say there's no 2.0 of Jason. No upgrade needed.
Monday.
Yes. All right, so what discovery is missing on this, Jason?
We're not entirely sure. The detective indicated that there was a restaurant that may have surveillance video. We just need to see if he collected it. So I'm planning to email the detective this morning. I just don't know if he'll get back to me because I believe he had tonight the ID. So we know.
All right. And I will give you guys another discovery setting, but this will be the last discovery setting. So is 30 days enough time for each party?
I think
That should be plenty of time.
yeah.
for us to-
All right, so what we'll do is we're in February. So we'll set it for March 6th.
March 6th.
Yes. Is that a good date for you,
That'll
council?
work. Yes, ma'am.
All right, so Ms. Ferguson will give you a reset form, and this is discovery for potential video from another location.
Yes.
All right. And that's the only discovery,
And
nothing
there's
else.
some reports that there were indicated there were some previous altercations between the two families. That there may be some reports that the officer was going to look for as well. That's noted in the offense report.
All right, so they say they want video if it exists and any prior reports between the relationship. Will you be able to do that?
Yes, sir.
All right, thank you.
Thank you.
Just
Judge.
get a reset form, Ms. Ferguson, and your excuse.
Oh, Judge, my client is still on GPS. Is it possible that we could have a hearing to have it removed? She hasn't had any violations. She's been on it since she was released.
You want to confer with the state?
I'll talk to her.
Sure. If there's not an agreement, then we'll have to set it for a hearing.
Yes, ma'am.
Yes,
Did you call the trial document?
yes.
I was hearing, I'm hearing Marcelo Scott, Judge.
Okay,
Did the state make an announcement?
I'm sorry?
Did the state make an announcement?
No. And Norma, can you call Mr. Hopke? And tell him he's needed. And counsel, are you ready on Christopher Armstrong? It's Fernando. He was here. Okay, yes, sure.
The order we talked about last Friday
Okay,
for Mr. Hoffman. I think I got everything that you said.
okay.
Thank you very much, Your Honor.
You're welcome. All right, thank you. Oh, I didn't because the printout wasn't legible. So I put that in that's the only way I could write. Yeah, nothing's legible. So if you could, yes, That's why I couldn't read. The lines were all together, and it's even worse on the screen. No. Is Lade not here? Can we get him over? Yeah. Well, did somebody call? Call and see if we could get him here.
Thank you, ma'am. Yeah, I thought of client here and then I want to try to be fine. There's something. Yes, last name is okay. That's on the order from that from my side. Thank you very much. Medication.
Who's here? Mark Anthony Pena.
Good morning, Judge.
Good morning.
Reed with Derek Rich's office.
Yes.
Judge, we followed.
Where's your client?
He's here, right there, standing up.
Oh, he needs to come forward. Come forward. All right, we're going to go on the record. I need everyone to please be quiet in the box. Court is calling 2023 CR 0037, State of Texas versus Mark Anthony Pena. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Sydney Reed for the defense.
All right, and are you Mr. Pena?
Yes.
All right, so the attorney listed is Derek Ritchie.
Yes, I work for Mr. Ritchie.
All right, any objections to this attorney standing in for Mr. Ritchie, state?
No, Your Honor.
Mr. Pena, do you have any objection?
I haven't had any contact with them.
All right, my question is, do you have any objection to her standing in for Mr. Ritchie, or do you want Mr. Ritchie here? If you want Mr. Ritchie here, then Mr. Ritchie will be coming here. So that's my question to you. All right, let's bring Mr. Ritchie in.
Mr. Ritchie has three CPS hearings this morning. He's not available, which is why I'm standing in. He can come in later this morning, but it won't be until after 11.
All right.
Okay.
Thank you. And are we ready on Mr. Armstrong, counsel? Alberto Rodriguez, Are you rating it on Mr. Christopher Armstrong? It was from yesterday. I'm sorry, from Friday.
Didn't you bring them out already?
Yes, but remember we were waiting for the results of his UA
Yes.
and they were positive for meth, amphetamine, and marijuana. So he's in the box now. So I don't know if you wanted to talk to him or if you want him brought up and I'll sentence him, but I'm going to change and add referral to felony drug court.
Well, we can do that now, y'all.
All right. Court is calling 2022 CR 11229, State of Texas versus Christopher Armstrong. Christopher Armstrong, could I have parties announced for the record? For the state?
On behalf of the state, Your Honor.
Defense?
Yes,
And are you Christopher Armstrong?
Your Honor.
All right, how are you feeling this morning?
Great.
All right. And you understand why I took you into custody?
Yes, Your Honor.
All right, I did it hopefully for your protection. So the court had made a ruling, but I'm going to add to that. Counsel, your client was positive for methamphetamine, amphetamine, and marijuana. I didn't place him under oath to make any admissions because you were not here. But I would like to speak to him so I can figure out what conditions to place on him. Do you have any objections to that, counsel?
No objections, Your Honor.
All right, Mr. Armstrong, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. State your name for the record.
Christopher Michael Armstrong.
All right, so Mr. Armstrong, you tested positive on Friday. Can you tell me how often are you using drugs?
Maybe once, twice a week.
Okay. And are you employed?
Yes, Your Honor.
Have any children?
Yes, Your Honor.
And what are their ages?
17 and 13 are my two youngest.
All right, and what was the person who was here yesterday when you said they had to get home because there was a 3-month-old? What is your relationship to
That
them?
was my ex, that was my ex-girlfriend, but I was her ride back there. So,
Okay, why did your ex-girlfriend need you for a ride to court?
because she was coming to give me some support to come to court with me.
I don't understand I think relationships are what they are, but I don't understand an ex-girlfriend who has a babysitter for a 3-month-old who's not going to be there for the entire day coming down to support you on an unauthorized use.
I don't know, she was just there to give me support, like just to go with me.
And is she using?
Yes, Your Honor.
All right, so I don't know what Child Protective Services is doing, but what is her name?
Trisha Tahiti.
How do you spell her first name
Trisha, Trisha.
and her last name?
I would not be able to tell you that one. Tahiti.
And where does she live?
Off of 475. Wait, hold on. Give me a
Sir, you
second.
need to have a seat.
Give me a second.
All right, just have a seat. We'll get to you.
Villa Drive. Villa, Villa.
So you say it's 475 Villa Drive
Yes, Villa Drive.
and it's Trisha, last name,
Tahiti.
Tahiti.
Yes.
And so there's a 3-month-old there and any other children other than the 3-month-old? And what drugs is she using?
The same. The child's not 3 months old. The child's like 7 years old.
All right, that doesn't make it any better, but okay. So the child is 7 years old?
Yes, ma'am.
All right. And she's using meth as well?
I believe so. Yes, ma'am.
All right, so hopefully Child Protective Services will go to 475 Villa Drive to check on a 7-year-old with Trisha Tahiti. Again, this is not a Child Protective Services court. There's nothing I can do about that. My hands are tied, but probation.
Yes, Your Honor.
I'm sure Mr. Christopher Armstrong has lived at that address. So if you could have probation go out to 475 Villa Drive just to check and see if it's appropriate housing for Mr. Armstrong.
Yes, Your Honor.
And if while they're there, they discovered that Miss Tricia Tahiti is using and the child is in danger, they can call Child Protective Services. All right, so this is what we're going to do. I will grant your application. So it's going to be 2 years deferred adjudication, $1,000 fine probated, proof of employment within 30 days, no employment as a home healthcare provider with minors, restitution of $600, and no contact with Apollonia Albzio, ALBZIO, 100 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. Parenting classes with P, regular reporting by Zoom or in person, regular UAs. I'm going to want field visits 2 times per month. And you know what, instead of regular UAs, we'll do the UA hotline. And we'll start off with testing him once a week. And if probation feels like that should be decreased, then I'll leave that up to probation to do. And if probation wants to count the UAs or the field visits as reporting, probation can count that. And I'm going to want a TAP evaluation and felony drug court referral while in custody. Follow all recommendations of TAP. If TAP evaluation says inpatient treatment, we'll start with intensive outpatient treatment. If they say outpatient treatment, I still want us to start with intensive outpatient treatment. And if you're released or when you're released, where will you be living?
8819 secluded drive,
8819,
secluded, that's SECLUDED,
wait, SEC.
LUDED.
Oh, secluded drive.
Yes, ma'am.
All right. Does anyone live there with you?
No, ma'am.
All right. And then no unsupervised contact with minors.
Yes, ma'am.
That will change, and it can change once you're into your sobriety. You understand?
Yes, Your Honor.
All right. Is there anything else you need from the court?
No, Your Honor.
All right. Counsel, for some reason, I don't have his trial court certification. Could you, let me see if I can find it. Just one
I
moment.
think we did it, Your Honor.
Oh, okay. Did you review the trial court certification with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, so Mr. Armstrong, with regards to the evaluation for the TAP evaluation in felony drug court, since it's a Monday, they'll be able to see you this week. So they'll probably see you no later than Wednesday.
Yes, Your
And
Honor.
then probation, if you want to accept their version of the TAP evaluation, you can.
Okay, do you want the TAP evaluation in custody? or-
Yes.
Okay, and Your Honor, on Friday, you mandated restitution, you ordered restitution,
Yes.
still the same, correct?
Yes, still the same. And it's $600.
Okay.
All right. Is there anything else?
No, Your Honor.
All right. Good luck to you, Mr. Armstrong. We can go off the record. Mr. Armstrong, in this court, if I place somebody on probation, I want them to be successful at it.
Yes, Your Honor.
So the key to being successful on probation in this court is communication. You need to make sure you report, make sure you do your UA. You know, I understand that sometimes when people are struggling with addictions, they may test positive. But what I don't understand is when people don't report and they don't communicate. You understand?
Yes, Your Honor.
All right, good luck to you. Is there anything else you need?
No, Your Honor.
All right, good luck. Thank you, counsel.
Thank you, Your Honor.
Who's here on Donald Davis? And Mr. Davis, if you come forward. All right, what are we doing with this case?
We have an offer in the case. We're not accepting the offer.
All right. So I'm going to give you a plea deadline date. we're going to come back in 2 weeks for his plea deadline date. And then after that, you'll be given a trial date. Do you understand? All right, counsel, is there any outstanding discovery?
Not that I'm aware of, Judge, no.
All right, so if I can get an acknowledgement of discovery before you leave here today. And Ms. Ferguson, I need a plea deadline date in 2 weeks for Donald Davis. All right, so we'll see you back on February 23rd. And you'll get a reset form, then you're excused. Mario Carranza. All right, has an offer been tendered in this case?
It has, Judge.
All right, when was the offer tendered?
It was last week.
All right. I'm going to give you a plea deadline date. Ms. Fergus, can I have a 2-week reset on Mario Carranza, please? All right, we're going to come back on February 23rd. At that time, you need to let the court know whether or not, yes.
And you have a vacation letter on file for that day,
All right, when's your vacation?
that Thursday through Friday, yeah, Thursday, Friday.
All right, Ms. Fergus, can we put this on the 21st? Or the 20th? I'm sorry, 21st. All right. We'll come back on the 21st. The 21st will be your plea deadline date. At that time, you'll have to let the court know whether or not you're accepting the offer. If you choose not to accept the offer, then the court will give you a jury trial date and the court will not consider any offers after that date without good cause. Otherwise, you'll have to fly open to the court. Do you understand? All right, Ms. Ferguson, we'll give you your reset form.
Judge.
Hello, hi. We're ready to proceed to continue with the hearing.
Okay, I need to file it.
All right,
I have one thing I need to file real quick, and then I'll meet for quickly with my client.
all right. Let me see. Roland Lopez.
He's downstairs, Your Honor. Yeah.
All right, thanks.
I forget. Yeah.
Hello. Oh, and I received that information, so I have it.
This is great.
I can help with the files.
All right, thank you.
File this. Yeah. there's a bunch. This is one. Bad situation.
Who's here on Lisa Pierce, Lindsay Pierce?
Jason Todd from Spears. And Mr. here as well.
All right, she needs to come forward. All right. And who is the prosecutor on this?
Ms. Mitchell.
Sure. All right, on January 8th, I have before me a motion to amend pretrial conditions. On January 8th, she was approved for the Make-A-Wish to travel to Florida. And the new motion is saying that that trip was rescheduled due to illness. And so now it's been rescheduled to February 25th and March 2nd. Am I understanding the state was objecting to that?
No, I'm in agreement with the previous
Okay.
agreement. with it.
All right, would you like me to? Are we good? I can talk about why we're here if you want, or if we're good.
No, I mean, I've read the motion. It was previously granted.
Yes, Judge.
What's the next court date for this case?
It's today.
All right, so what's happening with this case?
At this point, we're conferring. There's two victims. I know and obviously the state can speak for themselves. It's my understanding that they're still reaching out to the second victim.
That's true. We have made contact with one, and we still need to talk to the second, who I think is probably gonna be the one who feels very strongly about this case.
All right, so is there any discovery issues?
Not at this point, Your Honor, no.
All right, so I need a discovery acknowledgement done today. And Ms. Ferguson, can I get a 30-day reset on this case, please? All right, we're going to be back on March 9th, and on March 9th, state will make you an offer.
Thank you, Judge.
All right, Ms. Ferguson will give you a reset form.
Thank you, Your Honor.
You're welcome.
May we be excused?
After you sign the reset form and after you sign the acknowledgement of discovery.
Thank you, Judge.
Sorry. And Norma, you recall that for March 6th, correct?
The 9th.
The 9th, okay. All right, who's here on Roland Orta?
I am.
All right, Mr. Orta.
Roland. Roland.
All right.
My client is real hard of hearing, Your Honor. One, one side doesn't work, the other side works a little bit better, but so let's try to get through this, Judge.
All right, so Mr. Orta, why were you late today?
He wasn't late, Judge. He was in your courtroom.
Okay,
I went to go track him down.
all right, thanks. So Mr. Orta, now you know where the court is, correct?
You know where the courtroom is now, right now?
No, 227, no.
Yeah, well, no, you went to the 227.
Moving to 87.
Yeah, but they moved it, so now you know where to come, right? Right?
Yes.
Okay.
Okay. All right, and where are we on this case?
Your Honor, we have not been able to talk to the victim. He was actually, we learned this morning, arrested for ag assault over the weekend. So it may take a minute for us to be able to get him an offer. But we would just ask for a brief reset to
Judge, I'm gonna,
assess the case.
yeah, I'm sorry. I'm gonna be on, spending a little time with my grandkids, spring break the first couple of weeks of March.
Okay. Are you spending time with them to spoil them, or are you just?
What do you think?
Your children are gonna be like, you never did that for us.
Yeah, I'm looking forward to it.
All right, so when is your spring break?
Well, it staggers because I have one's older than the other, so first 2 weeks probably of March, I'm gonna be occupied with them.
All right, Ms. Fergus, can I have a 30-day reset?
The 23rd.
All right, is the 23rd a good date for you,
Yes,
counsel?
Judge.
All right, so when we come back on March 23rd, state you need to have spoken with your complainant
Will do.
I'll
and
stand
make
by
an
this-
offer.
I'll stand by the sign of discovery acknowledgement. I think I have everything.
All right, thank you. And Ms. Ferguson will give you a reset form.
Okay, Judge. Nice to see you.
You too.
Can you talk to us?
It really was.
Okay.
Where is Mr. Hopkey? All right, would you call Mr. Hopkey and tell him we're taking up his case now? Thank you. Ah, here's Mr. Hopkey. All right, Mr. Hopkey, are you ready to proceed?
Yes, Judge, I do have another witness on the way. She said she'd be here in about 5 minutes, so.
Okay.
We
All right.
give it a little bit of time.
State, do you have any witnesses?
We have a potential rebuttal witness, Judge.
Okay.
And Judge, I did file a motion to quash alleged allegation or motion to quash allegation. I don't know if Caroline gave it to you or not.
All right, yes, I've received it.
Okay.
All right, is there any other witness here for the state? State, you're saying it's a rebuttal witness. Who is the rebuttal witness? potentially?
The probation officer, Priscilla. Priscilla Cisneros.
All right, I didn't know if you all wanted to call her because I know there's a shortage.
Oh, I mean. I guess if the defense is object, because I believe we're still on direct examination of the defendant.
All
But
right, so, well, let's finish with your direct examination of your client. Are you ready to proceed, counsel?
Yes, Judge, and I do have one other witness that said she'd be here about 5 minutes.
Okay.
She said 20 minutes, about 15 minutes ago, so.
All right. We're going to go on the record. Court is calling, and Mr. Jimenez, if you need to continue to speak to your client, if you all can move towards the end, and the deputy will move in. All right, court is calling 2018 CR 0165, State of Texas versus Roland C. Lopez. Could I have parties announced for the record for the state?
Jason Jorgens for the state.
Defense?
Kurt Hockey for the defense.
All right, and are you Mr. Lopez?
Yes, ma'am, Judge, I am.
All right, so where we left off on Friday, I believe, we were on direct examination with Mr. Lopez. Is that correct?
Yes, Judge.
All right, you may continue.
Okay, and I believe we left off last time talking about his employment.
All right, you may proceed.
Okay. I thought I printed something out, but I guess I didn't. Okay. Now, on the 17th day of November 2022, did you have a change of address?
No, sorry, I didn't.
All right, I'm gonna need you to speak up.
No, sorry, I didn't.
Did you have a change of job?
No, sorry, I didn't.
Did you had you been arrested and not reported it to probation?
No, sir.
Okay. All right, on September 8th, 2021, did the probation office do a field visit on your house?
Yes, it did. And I was at work.
Okay. Actually,
Or maybe at the gate, if I'm not mistaken, that one.
All right, so everyone, could you please whisper? And then when you come before the court, if you could please talk so that the court can hear.
all right, so raise your voice, okay?
Yes,
September 8th, you met them at the gate?
yes, sir, I did.
Okay, and it was a routine field visit, right?
Yes, sir.
Okay. All right, and then on September 14th, did they come to your house?
Yes, sir, I believe they did.
Okay, and everything was fine on September 14th?
Yes, sir.
Okay, on September 16th, did they come to your house?
Yes, sir, they did. Oh,
Do you want to review to refresh your memory?
yes, please.
Don't worry about that. Okay. Review this. And. You read this and see what we're talking about here?
Yes, yeah.
Okay, so on September 16th, did they actually come to your house?
No, sir, they didn't.
Okay. When was the next time they came?
The 21st.
Okay. Okay. So on September 16th, they actually did not come to your house?
No, sir.
Okay. All right, pass the witness, Judge.
All right, state.
Mr. Lopez, you signed conditions of probation, right, when you were placed on community supervision?
Yes, sir, I did.
And you understood them, right?
As fully as they read them to me.
I'm sorry, so you did understand them?
Yes,
And obviously you knew the importance of following them, right? Because otherwise the judge could potentially revoke your community supervision.
yes, sir.
And I believe we're here now on a third motion to revoke community supervision, is that right?
I believe so, sir. Yes.
Okay, so let's talk about this one. So you talked with your attorney about, I guess your address hasn't changed and your employment hasn't changed in, I guess, in the timeframe that we're talking about for this motion to revoke, right?
Yes, sir, it has it.
Right. And were you living by yourself or with your mother at this time?
My mother.
Okay. Does anyone else live in that house with you?
Yes, her boyfriend.
Okay. Anyone else?
Yes, and my common law.
Anyone else besides those two?
No.
Okay, so just your mom, her boyfriend, and then your common law spouse.
Mhm.
Okay. So you talked about no change in your address or occupation, but I mean, you understand one of the conditions of probation is that you have to provide proof of that, right? That you're still living at that place and that you're still working at that establishment.
Objection, that's a mischaracterization of probation condition number 4.
Overrule. You can answer the question.
Yes, via provided my email of the officer because everything was via Zoom.
And when was the last time that you provided that proof for your current residence before November in 2022?
I would believe that was when Miss Sarah Thatcher, PO at the time, roughly, I would say maybe in June.
Okay, so
Or May.
around June.
Mhm.
And how about your proof of employment? When was the last time that you provided that before November 2022?
Same time.
Okay. And had you been asked to provide it at any time subsequent to that?
Yes, Miss Sneddles and asked her for her email so I could go ahead and such documents be sent over to her plus UA receipts.
Okay, and when did you send those?
I never received the email.
When did you ask for the email?
The same time, I think it was in August and back again in November.
Okay, so Mrs. Cisneros just kind of fell down on the job and didn't provide you the means to provide for your address or employment.
I would believe so, sir.
No, we've got an allegation from June 30th of 2022. So at that time, it was Sarah Thatcher that was your supervision officer, right?
Yes, sir.
Okay, and that was for an allegation of failing to submit to a drug testing. Did you submit a drug test on that day?
No, sir. I was told by after prior to the same time this year, I would do a 3-month UA and it would end in May. And I was completed successfully and Ms. Earth Thatcher told me I had no longer to take UAs and the stipulations were completed or satisfied by the board.
She told you that you no longer had to do UAs for the rest of your probation.
She just told me no more UAs. Exactly just like that.
Okay, and I guess, did you take that also to mean that you didn't have to report to probation?
No, sir.
Okay, well, you heard the testimony of Ms. Abrams that you didn't report at all for the month of June 2022. right?
Objection, this is not an allegation in the motion to adjourn.
Overrule.
You remember that?
No, we had talked to Ms. Sarah Thatcher and they said they were giving me another PO that's supposedly she didn't work with the probation office no more.
Okay. So then, because you were waiting for another PO, you ended up not doing anything in June. Is that fair to say?
No, they told me that they were gonna be counting that as a, what do you call it, as a visit.
They were counting what?
Me calling in, letting them know
And when was
prior
that?
to them during June.
You called in June.
Yes, sir.
Who did you speak to?
I don't know his name. He was just a random personnel that was there that opened up for the, I guess, a clerk or whatever.
And then, so we've also got an allegation of failing to submit from November 17th of 2022. And that's kind of the day where I guess a lot of these allegations are coming from. So this one, I think we heard on examination with Ms. Abrams that I guess you had been directed to submit, but you said that you would work or something and you couldn't get off. Is that how it went out?
No, sir. She had asked me about my address and everything else, and I told her, like, please send me the email and everything. And she goes, well, can you go submit to a UA right now? I said, no, ma'am, usually with my work, the way probation for this past 4 years have been going. I said, my work doesn't really give me the opportunity now. They want advancement to be able to go do this. And I had to give them at least a day and a half, so they'll give me that whole day off so I can complete it. And then I asked her, do I still have within a month, like regular probation usually does, to be able to do it? And when I get a day off, I could go ahead and take care of it. And she said, yes.
Okay, so you weren't able to submit that day because of your work conflict, is that right?
Yes, sir.
Okay. Did she tell you to go the next day?
No, I think she might have said, well, what about tomorrow? And I said, it's the same thing with work. I got to give them 24 hours in advance.
I got you. So when was the next time that you submitted after November 17th of 2022?
November 28th.
Okay, and did you go in on your own or did a probation officer ask you?
No, went out on my own, sir.
And we've got a few allegations for not conducting yourself properly and orderly at the probation office. Let's talk about the November 17th allegation, November 17th, 2022. So in that case, or in that incident, were you letting Mrs. Cisneros explain what was going on with your probation, or how were you responding to that?
I don't follow the question, sir.
You believe that you were conducting yourself in a proper and orderly manner on November 17th?
Yes, sir.
Do you believe that you were talking over the officer?
No, sir.
And on July 13th, 2022, we got another allegation for failing to conduct yourself in a proper and orderly manner. Do you remember that day, July 13th, 2022?
No, sir.
No.
No,
Do you remember ever being escorted out by security from the probation department?
no, they never escorted me out whatsoever.
And so during your meeting, November 17th, 2022, you were able to talk with Mrs. Cisneros, right?
On November 17th?
Yeah, 2022.
Via Zoom?
Via Zoom, okay. And you weren't able to provide any kind of proof of employment or address at that time because you didn't have her email.
Yes. And once again, I asked her for her email during that time too.
And she just refused to give it to you.
No, she just said, I'll send it to you, but it never popped up on my email.
Okay, but you were talking right there, so she's just deciding not to give it to you.
No, exactly. She didn't give it to me right off the hand. I gave her mine and she was to send it to my email. So I know it's her and never arrived.
And are you still living at that same address to today, assuming you weren't in custody?
Yes, 1449 Chalmers.
Sorry.
1449 Chalmers.
So Judge Boyd gave you a chance to be on probation, right? Back in July of 2018, she gave you a chance to be out in the community and show that you could be a productive member of society, right?
That was states in our agreement to get back up.
Sure, but it's up to her to follow the agreement. right?
Yes, sir.
So she gave you that chance.
Yes, she did.
And then she gave you a second chance, right, with your first motion to revoke to keep you on community supervision.
Yes, sir, she did.
And she gave you a third chance with your second motion to
Objection,
revoke,
relevance.
Overrule.
right? She gave you a second chance.
Yes, sir, she did.
Or I'm sorry, a third chance, right, at that point with the second motion to revoke. And so now you're asking her for a fourth chance to complete your community supervision?
Yes, all of my prior ones were for recovery, and I took advantage of that, and I went ahead and got recovery. As it states on the other one, that I have all the 3 months that she sent me on this last one, I completed them successfully, and I still am drug free and don't touch drugs at all.
Well, that's good, because you were talking with your defense attorney about regularly submitting UAs, right? Like you
Objection.
regularly.
It's
He
a
brought it up in the direct
mischaracterization.
examination.
Sorry.
Overrule.
Judge-
And everyone. So it's Monday. As I said previously, some people thought they would be retired. We're not retired. So I try to make everyone's job as easy as possible. And the way we do that for the court reporter is one person speaks at a time. If anyone has an objection, please raise your objection after the person has finished their question. I will make a ruling on the objection and then we can continue. So state, what's your question?
Our question was whether Mr. Lopez remembered talking with his defense attorney about regularly submitting UAs.
Objection, that's also attorney-client privilege.
All right, that will be sustained.
It was during direct examination, Judge. The defense elicited testimony that he had regularly submitted UAs while he was.
I don't think.
All right, so
Objection,
here's,
I don't think I
stop,
said that.
stop. So I'm going to sustain the objection. State, if you want to ask the defendant the question, whether or not he has regularly submitted UAs or has previously stated that he has regularly submitted UAs under questioning from his counsel, I'll allow that.
Okay, Judge. Sorry, I thought that's how I phrased it.
No problem.
Originally. Mr. Lopez, do you remember talking with your defense attorney on direct examination and saying that you regularly submitted UAs while you were on community supervision?
Yes, it was for the time this past probation of me doing the 3 months of the UA weekly.
Right, and so that's what you're talking about when you're saying that you're drug-free now, right?
Ever since then.
Sure. Because you have been testing positive while you've been on probation, right?
Objection, relevance, not in the motion to revoke.
And Judge, we're not trying to prove that. We're going to the allegation of violation number 2.
All right, that will be overruled.
You can answer the question, sir.
For
You
the,
have tested positive since you've been on probation.
have I been tested positive? Not that I know of. Everything's been coming back that they tell me that it's been negative. If not, then there would have been a warrant put up on my arrest.
Okay, every urinalysis that you've submitted since 2018 has been negative, your knowledge.
No.
Oh,
That's
okay.
why I was talking about recovery. Ms. Boyd gave me the chances on those other times because I came out dirty and she told me to find recovery and that's what I did.
Sure, so you have tested positive since you've been on probation.
Yes,
And you're saying that you're not using drugs now, right?
no, sir.
But unfortunately, the court doesn't really have a way to know that because you failed to submit, right?
No, sir.
Really, June? So in the month of June 2022, you submitted.
No, sir, I didn't. I did have a PO. They told me at the end of May that I had to do no more UAs no more. That was satisfying the judgment that was taken care of for the last MTR.
But you know that's not true, right? Because you submitted a UA in November, but you knew that you still had to do UAs.
Because Ms. Miscellaneous had asked me to go submit one when I was at work and I told her I'll go when I have a day off and that, or if not, get my company to be able to let me off. And went ahead and did that. I think it was on the 30th or something like that, 29th or the 30th.
Okay, so you just had to do it on your schedule, not probation schedule.
No, sir.
No, oh, so you were able to do it on probation schedule. And when she told you.
Objection, argumentative.
Overrule.
So when you were told to submit on November 17th, you were able to do it on probation schedule.
No, sir. It wasn't a random.
That wasn't my question, though. It was, were you able to do it on probation schedule? When they told you to report and submit a UA, were you able to do that on November 17th, 2020?
Objection, asked and answered.
All right, that'll be overruled.
No, sir.
No, you were not able to submit.
No, sir.
Well, that's one.
Defense.
All right. Now. Regarding, you were asked to do UAs for 3 months weekly up through May. And then you were understood at that point that you did not have to continue to submit.
Objection leading.
That'll be overruled. You can answer the question.
At that time, PO Sarah Thatcher let me know that I was satisfying the judgment of the 3 months of not coming out dirty and everything that was held in advance, the safety and the yearly deal, which would be and wait for July to come up and I'd have to do more UAs.
Okay, and you were never notified to submit on June 30th, 2022.
No, sir.
In fact, you were told the opposite, that you did not have to.
Yes, sir.
Okay. You had previously tested in May, correct?
Yes, sir.
And you also tested in July.
Yes, sir.
And both those times they were negative.
Yes, sir.
Okay. And in October 28th, 2022, you did a drug test, right?
Yes, sir.
And it was negative.
Yes, sir.
Okay. If you took off of work on November 17th, as Ms. Cisneros asked you to go submit a drug test, where would you have to drive to do that? How far away from work?
I would say about a mile away.
Okay.
I'd say about a mile away at the RMS. It's the only place that they allow us to do it for probation.
Okay.
And usually they're backlogged up. And if I would go at lunchtime, they'll be working on the people that clocked in at 10 a.m. So it'll give me a 2-hour window that I would have to wait. And that'll be past my lunchtime period.
Okay, so it would take at least 2 hours to do a drug test. Is that your common experience?
Yes, sir.
Okay, and if you miss 2 hours of work, what would Freeman Expedition do?
Terminate.
Okay. You had a deal with work that if probation made.
At this point, I think he's got his point across.
All right, that'll be overruled.
But you had worked out a deal with your work that if probation made these demands of you, you could arrange for a time to do it and it'd be okay with work where you wouldn't lose your job.
Yes, sir.
Production call for consent.
That was-
That'll be sustained.
That was your understanding of the agreement, right?
That's sustained.
Okay. Okay. And you did were able to complete a drug test on November 30th.
Yes, sir.
And it was your
Objection,
understanding.
mischaracterized the testimony.
That'll be
He testified
overruled.
to November 28th.
That'll be overruled. Everyone, as I tell people, I have a mind that's a steel trap. So I remember everything that everybody has said. And I will make a judgment on the credibility of witnesses.
Okay. Be a minute, Judge.
Sure. And Ms. Ferguson, who is the interpreter here for?
You just stepped down to. the text.
Thank you for coming. As soon as the attorney comes back, we'll take your matter up.
We'll read this and refresh your memory.
Wait, Judge, I guess we're gonna object at this point. He hasn't testified that he's failed to remember.
Yes, what is he not remembering?
Okay.
And we're off the record for a moment. It is amazing that when we're not on the record and nobody's saying anything, everybody gets quiet. And the minute somebody starts asking questions, that's when everybody starts talking. So to the people who are approaching the coordinator, when we're on the record, please don't approach and speak with her because it makes it difficult for everyone to hear. All right, we're back on the record. You may proceed.
All right, Judge, I'm gonna move on. All right. Now, you testify that you've been drug-free for how long?
I would say close to a year
Okay. And you've been on probation for how long?
since 2018.
Okay, so we're almost 5 years.
Yes, sir.
You were originally on probation for 4 years.
Yes, sir.
Okay, do you know when your probation ends?
This one's supposed to be in July.
Okay, so you have about 6 months left on this probation?
Yes, sir.
And you've been working,
Yes, sir.
you've been drug-free,
Yes, sir.
you haven't picked up any new law violations?
No, sir.
Objection, ask an answer for this one, Judge.
Sustained.
If judge allows you, do you think you can successfully complete this probation?
Yes, sir, I can.
Pass the witness.
State.
Nothing further.
All right, defense, any other witnesses?
Let me see if my other witness is here. If I can make a quick phone call.
Yes. All right, Mr. Lopez, we have you take your seat while your attorney does that. And is the attorney here with the interpreter? All right, who's your client? All right, if I could have, yes, so he has Hector Lopez, someone. Who's your client? Yeah.
I'm sorry.
Thank you. All right, so we have an interpreter. We're not on the record. What is happening with this case?
I just conferred with Mr. Gorgon and the case judge, and it looks like the state is going to be re-indicting the cause as a separate case. We're still conferring. I'm still receiving discovery. I still received some yesterday on this case.
All right, state, are you anticipating on re-indicting this case?
Yes, Judge, within the next week, I'm hoping to do it this week, but within the next week or two. Also, this particular defendant has several co-defendants. So I agreed to look at this defendant's culpability to make sure that there's sufficient evidence to charge him. We're good on the other co-defendants, just need to review this one, Judge.
All right, when are the co-defendants cases set?
I believe they were set last Friday, if I remember.
All right, Ms.
It may have been earlier.
That's probably correct, just because I had to reschedule him for today because I was out last Friday.
All right, Ms. Ferguson, can you look up to see when the co-defendants are set? 2022 CR 10958A. All right, so we'll come back on March 21st. And is your client a citizen? Does your client need an immigration attorney?
Probably, Judge.
All right, Ms. Ferguson, if we can get an an immigration attorney for Mr. Lopez. Mr. Lopez, the immigration attorney that will be appointed to represent you is your immigration attorney as it relates to the impact this case will have on your immigration status. It is not a person who's appointed to represent you globally with any immigration issues. Do you understand?
Yes.
All right. Is there anything else from either side?
Not from the state.
Not for the defense, and just March 21st, correct?
Yes. All right. And Ms. Ferguson, can you make sure he has an immigration attorney? All right. And see if they can come over and see him today if possible. All right, Mr. Lopez, are there any questions?
No.
All right, thank you. We'll have an immigration attorney come speak with you. And counsel, if you just remain, usually the immigration attorney is pretty quick about coming in, just so you can confer with them. All right, thank you.
Thank you.
Yes, thank you so much for coming. Always a pleasure to see you.
Oh, likewise, Rob. Thank you.
Who's here on Brittany Brown? Brittany Brown. Where's her attorney? Who's your attorney?
Ms. Rodriguez. All Rodriguez.
Just one moment. Let me see where he is. Caroline? Oh. Mr. Rodriguez? Hi, we're ready to proceed on Brittany Brown. All right, the court is calling. If you all can stop conferring in that area. Court is calling 2023 CR 0042, State of Texas versus Brittany Merrill Brown. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense.
Rodriguez.
And are you Ms. Brown?
Yes.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Brown, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it and did you sign it? Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Waive it, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we move to waive the advancement and proceed as a class A misdemeanor assault.
Any objection?
No objection, Your Honor.
Ms. Brown, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand that the state is proceeding on the lesser included offense of assault, bodily injury, married cohabitation as a class A misdemeanor? The range of punishment is up to 1 year in jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargaining agreement with the state, the court doesn't have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
I did not understand that one.
All right, you don't understand you have a right to jury trial?
I mean, I heard it, but I didn't hear it.
All right, so do you need to speak to your attorney?
No, can you please repeat the question?
Do you understand you have a right to jury trial?
Yes, I don't.
All right. Do you understand that you have a right to have your attorney cross-examine or question any witnesses the state would call?
Yes, ma'am.
Did you understand you have a right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you're giving up your right to a jury trial?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you're giving up your right to have your attorney question or cross-examine witnesses?
Yes, ma'am.
Did you understand by entering this plea, you're giving up your right to remain silent?
Yes.
And did you intend to do that and enter into a plea bargain agreement today?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Brown, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial, showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, punishment is to be assessed at 1 year in the Bexar County Jail. State recommends community supervision. There's an affirmative finding of family violence. I'm going to need you all to be quiet in the box, please. There's an affirmative finding of family violence. There's to be no harmful or injurious contact with Tegui, Tegui, Bizu, Biezou. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
That's forever?
You're not allowed to own or possess any weapons or ammunition. Do you understand that?
I mean, yeah, but I can never, for protection,
You need to speak to your attorney about that. But with an
Okay.
affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition.
Okay,
Do you understand?
yes, ma'am.
And with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent. Did you understand that?
This is the first time I heard of that.
All right, so I'll let you all step back. So
So
you
I'm
can,
no, what does that mean?
I'll let you
That
speak
I'm
to
not-
your attorney about that.
I'm not allowed to have children?
Oh, you can have children, but if there's some sort of custody issues that arise, technically and legally, the court is not allowed to have you as primary custodial parent. Now, if in the best interest of the children, they determine that you will be the best placement, then they can do that. But if there were any type of custody issues, and there's a person who appears to be a good parent and they don't have an affirmative finding of family violence, then they're supposed to be designated as primary custodial parent. I'll let you speak to your attorney about it. So I'll have you all step back and you can talk to your attorney. And counsel, if you could talk to her also about the possession of weapons or ammunition. All right, thank you. Who's here on Gaydon Cantu? All right, if you all come forward. And Caroline, on this, just let me know when they're ready. All right, I need everybody to please whisper. Court is calling 2022 CR 10584, State of Texas versus Gaydon Cantu. Can I have parties announced for the record for the state?
Pictures on behalf of the state, Your Honor.
Carlos Martinez for the defendant.
And are you Miss Cantu?
Yes.
All right, we have an interpreter who's present. If the interpreter, if you could raise your right hand for me, please. Do you solemnly swear or affirm you will faithfully translate from Spanish into English and from English into Spanish? So help you God?
Yes, Your Honor, I do.
All right, you can lower your hand.
Thank you.
Counsel, all of these documents are in English. Were you able to review these documents with your client in Spanish?
Yes, Your Honor.
And do you speak Spanish?
Yes, I do, Your Honor.
And do you speak Spanish fluently?
Yes, Your Honor.
And were you able to communicate with your client in Spanish?
Yes, Your Honor.
Ms. Cantu, all of these documents are in English. Did you review those documents with your attorney in Spanish?
Yes.
And were you able to communicate with your attorney in Spanish?
Yes.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Cantu, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and did you sign it?
Yes.
Did you review the document entitled True Bill of Indictment with your attorney? And did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are proceeding on a lesser included offense of assault and bodily injury.
As a Class A misdemeanor?
That is correct.
Defense, any objections?
None, Your Honor.
Ms. Cantu, did you review the document entitled Court's Admonishment and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes.
Did you understand you're being charged with the lesser included offense of assault bodily injury as a Class A misdemeanor? The range of punishment is up to 1 year in the Bexar County Jail. and up to a $4,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
In my opinion, she does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
In my opinion, yes, Your Honor.
Ms. Cantu, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel, the court sees that Teresa Coles Davila was appointed to represent her as an immigration attorney.
Yes, Your Honor, and I spoke to her personally myself, and on a couple of occasions, she explained everything, how the Padilla matter works, especially that she needed to be advised before she entered the plea about the possible consequences of immigration consequences. And she claims that she still is gonna be able to keep on working on her immigration issue to help her obtain the proper documents to stay here.
All right. So did Ms. Coles Davila explain to her the impact or consequences of entering a plea in this case and her immigration status?
Yes, Your Honor.
Ms. Cantu, were you advised of the consequences of entering a plea of no contest or guilty in the application of federal immigration law?
Yes.
Did that advice include possible consequences such as deportation, exclusion from admission to the United States, or the denial of naturalization?
Yes.
And do you understand the legal consequences of entering a plea to this lesser of included offense and the effect it will have on your immigration status?
Yes.
And knowing that, do you still wish to continue with this plea?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. According to the plea bargain agreement, the state is proceeding on the lesser included offense of assault bodily injury as a Class A misdemeanor. There's a $2,000 fine, and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes.
Did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
No.
Outside the agreement, The state is requesting that your deferred adjudication be for a term of 1 year. There be a TAP evaluation, 80 hours of community service restitution, no contact with Yolanda Castillo, L'Esperanza. Is this flea market or flea market?
Flea.
All right, flea market at 18600 Pleasanton Road, San Antonio, Texas, 78221. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
This one, the state introduces State's Exhibit 1 and all of its attachments.
Defense has no objections, Your Honor.
Ms. Cantu, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulation with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
The court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I've spoken to my client numerous times, and she says there was an isolated incident. This will never happen again. She even said it several times this morning. She said, "You guys will never see me here again." It was just bad judgment on my part.
All right, Ms. Cantu, is there anything you wish to say?
No.
All right, do you have any children, grandchildren?
Yes.
And what are their ages?
My grandchild is gonna be 21 in April. And the other ones, do I have to say all the ages of all the others?
Oh, is there a lot? How many are there? She's like, yes, there are a lot. How do you say a lot in Spanish? Mucho? Okay. All right. How many? I'm just curious now.
Many, 30.
30 grandchildren?
30 nietos.
Big family.
Yeah.
Yes, many.
All right. So you know what? The interpreter, when she interpreted it, she did that with a question mark and an exclamation point. I heard it in her voice. Well, good luck to you. Are you employed?
Yes.
And what do you do?
Cleaning.
She works for a cleaning company and has for a long time.
Okay. All right, this is what the court is going to do. 1 year deferred adjudication, $2,000 fine, that will be probated. 80 hours of community service restitution, 40 of those hours will be waived if she provides proof of the COVID vaccination with booster. Court is not requiring you to do that, but if you do, 40 of those hours will be waived. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no contact with Yolanda Castillo, or the flea market Les Esperanza Flea Market. At 18600 Pleasanton Road. There's to be regular reporting to probation by Zoom or in person, regular UAs. And we'll do anger management class. And once she completes the anger management classes, the remaining of the community service hours will be waived. Probation, is there anything else that's needed? Yes, regular UAs. Yes. And we'll do a field visit just for an introductory visit to see how everything is. And if everything's fine and you want to discontinue them, you can. If everything's not fine, then let me know. And if you see 30 grandchildren there, let me know that too. And tell them to do a head count. All right, Ms. Cantu, is there anything else you need from the court to be successful? No, everything's correct. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Yes. All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Yes. All right, good luck to you. We can go off the record. See, you know, you've spent so much money on this, and to go into the flea market was only $2. All right, good luck to you. You're welcome. Okay, that thank you she gave me wasn't in Spanish. No, I'm trying to learn. I can't learn if you all don't speak in the Spanish when you have an interpreter. Thank you. Always good seeing you.
Yeah, same here, but
All right. Who's here on carbon? Yes.
part of the argument was that they were gonna go in a car. Car is full of women, and then they couldn't because it was, the line was too long. What happened is they said, well, let's walk. I said,
You can pass it here.
"She
Thank
wanted to-"
Ah,
And that's what's.
oh, that's the problem. You know, people have told me that I should go to that flea market. It's great. All the years I've been in San Antonio, I've never been to a flea market
I
here.
haven't either, but she claims this, it's a nice place.
Okay. All right. Good seeing you. Have a good one. Yes, thank you so much. Who's here on Corbin Potswan? Or past Wa? We're going to find out how to pronounce that name when he comes forward. Corbin, come forward. How do you pronounce your last name?
Passport?
Pastwa. All right. So what's happening with this case?
Your Honor, we have conferred, the state and defense counsel have conferred, we've extended an offer. I have asked defense counsel to provide me something additional. And for those reasons, we're asking for a continuance on this matter.
What are you asking to provide? How long is this going to take for you to provide whatever they're asking?
Shouldn't take very long, Judge. We're also too working around the states. I think he's got some vacation plans, whatever.
No, state never has vacation plans. You just pull down another prosecutor.
Whatever.
Because if you become indispensable, then your pay should reflect that you're indispensable. So if there's not another prosecutor who can come down and stand in, then somebody needs to renegotiate their salary, maybe. I'm just throwing that out there. All right, Norma, give me a 30-day reset, and this is going to be your plea deadline date.
Okay, Judge.
All right, March 7th is your plea deadline date. After that date, the court will not accept any plea bargain agreements without good cause. Otherwise, you have to plea open to the court.
Okay,
Ms.
Judge.
Ferguson will give you your reset form, and you're excused. Deputy Laura, I would like to be indispensable.
Judge, I want to change the date. Could I do the 8th, Judge? I just noticed that I heard.
All right, the prosecutor just left. He's indispensable. All right, we'll put it for the 8th.
Okay, Judge. Thank you.
You're welcome. Samuel Rodriguez, come forward. Where are we on the, and where is Mr. Rodriguez?
I believe in the custody judge. He was on suicide watch. I don't think they brought him over. Apparently,
You're just upstairs.
Yeah, he's here.
okay.
Okay, so we'll have him brought up. Deron Crawford. Who's the attorney? Oh, hi, Mr. Montgomery. So you received all the discovery, correct?
Yes, ma'am, I have.
All right, state, I need a discovery acknowledgement.
Yes, ma'am.
And then we have a, today is his plea deadline date.
That's correct, Your Honor.
And what is happening?
I'm told that the state doesn't know if they're going to proceed.
State, what do you mean you don't know if you're going to proceed?
Not sure,
Oh,
about that, Your
it
Honor.
was a different prosecutor, Judge.
Okay,
I'm not sure about that, Your Honor. I was told by Ms. Mitchell as she was leaving that there were some outstanding jail calls on this. I don't know if Pat has received those or not, so that may prevent the
We
discovery.
may wait on the discovery if they need to add something to it.
so where is this case headed? That's my question.
The part of that is headed toward trial, Judge.
If Mr. Montgomery's client no longer wishes to plea, we are on the way to trial, Judge.
All right, no, his plea deadline date has expired. It's expires today.
As far as that goes, Judge, extend it at least through the end of the week so that if there's this new evidence that I've never seen, I need to be able to advise my client about that new evidence, and he can't make a rational decision about any plea offer unless he knows what's on the table.
All right, Ms. Ferguson, recall this for the 10th.
Thanks, Judge.
All right, we'll see you back on Friday.
Appreciate it, Your Honor.
You're welcome. You're welcome. Alejandro Trevino.
Morning, Rod.
Good morning. What's happening with this case?
This is the first setting. I'm actually filling in for Jessica Gonzalez, who may be keeping the jury or keeping the jury or announcing for a jury in the 290th. It being a first setting, I did confer with the state, and I believe that we do need more time to review everything. Also considering the type of case it is, and we would request a reset to the next setting.
All right, so state with regards to Alejandro Trevino, where are we on this?
Just conferring, I do believe it is the first setting. We did not discuss any kind of offer or anything of that nature, but I understand this gentleman is not the attorney's son.
Ms. Ferguson, it shows in the system that Nathaniel Navy is still on this. Has the substitution been submitted?
Yes.
Okay.
And it's Jessica Gonzalez.
All right, give me a 30-day reset, please.
Give you March 7th.
All right, you're going to be back on March 7th. And at that time, the state is going to make you an offer.
Thank you, Your Honor.
All right, Ms. Ferguson, we'll give you a reset form. Thanks for dressing appropriately for court.
After the summary sentence, may we be excused?
Yes,
Thank you. Your Honor.
you're welcome. Tremonte Singleton. Who's the attorney on Tremonte Singleton? Hello,
Morning,
good morning. How are you doing?
doing fine.
All right, so we're here. The last time we were here, there were supposedly discovery issues.
There are, and Judge, my investigator's trying to get some out of county paperwork. It's kind of the inception of this case.
What kind of out of county issues?
There was a court case where his DNA was taken and it linked back to this. And then nothing happened for what, 2 decades? 14 years?
All right, state, what's with this DNA?
Yes, Your Honor, I'm trying to pull up the status of that right now.
I conferred with Miss Mitchell and she was going to look into it and get us an offer, Judge. So we're still trying to get that discovery.
And what else is outstanding other than the DNA?
The information regarding the DNA. Other than that, the state has provided everything else.
All right, Ms. Ferguson, I need a 30-day reset on Singleton. All right, we're going to be back on March 7th. On March 7th, the state is going to make you an offer.
Thank you, Judge.
You're welcome.
Y'all have a good day.
Thank you. Have a good one. All right, Janelius Crew. Yes. All right, so we're back for jury trial tomorrow.
Yes, Judge, at the same time, we will have a motion for continuance. The issue being that private investigator received voluminous discovery less than a month ago. And the combination of the voluminous discovery and some personal tragedies that she's had in her life in that period of time, she's only, to be honest with you, Judge, she's halfway through the discovery that was given. And
All right.
to give you an example of what's in that discovery, we're talking about 2 phone dumps that go over years of, of time and all the evidence that's in those phone dumps. I received notice last week from my investigator that she's only halfway through. She hasn't even started.
All right, this case has been going on in this court since 2020. So the court will hear your motion for continuance, but he's going to be brought over dressed for trial tomorrow.
Correct.
So make sure that the clothing exchange, has that already happened?
Yes, it has happened, Your Honor.
All right, so he'll be brought over tomorrow for jury trial.
Yes, Your Honor. Thank you, Your Honor.
All right, you're welcome.
All right, Samuel Rodriguez. Where are we with the mental health? TD?
Your Honor, I believe I got a notice last week that he was rejected because they said that he was in suicide watch. He refused to interview. That perhaps after he stabilized, I did file a motion to cite. That perhaps after he's stabilized, they could revisit it.
All right, Ms. Ferguson, I need a date so we can get an update on his evaluation. So the motion to have him evaluated has already been filed?
It has. And I've had the informal already with Judge Carruthers.
Okay.
You said 30 days, Judge?
Let's do 45 days. And if it's sooner than that, then you can always bring him back sooner. But I know it takes a while for them to schedule the appointment and then for them to write to the report.
Yes, ma'am.
Is he due March 27th?
All right, so we'll come back on March 27th.
Big sweep.
Yes. Jose Lozano. All right, and where's Mr. Lozano? All right. Good morning. All right, thanks for dressing appropriately for court. So this was scheduled for jury trial.
So Judge, a couple different things. So first, I know Mr. Aguilera did just substitute in about a week and a half ago, 2 weeks ago. The state had provided a disc to prior defense counsel. We notified him it was on the fourth floor. Mr. Aguilera just picked up the disc. He'd never picked it up. So we just got that this morning. He had several body cams on it that we couldn't do through e-discovery, that we had to actually burn a copy of. The state was also going to ask if we could get a special setting due to the fact that the complainants do live in Florida. It is something that they would have to buy last minute plane tickets if we do actually go to trial.
I thought the people who buy the plane tickets are the state.
It's one of those things where we would need time in order to make those arrangements. Either they could make it and we reimburse, or we would make it and we just pay for it, but it's just something that would take time.
All right, because Ms. Ferguson used to be my advocate and we would fly people out the next day.
I understand that, and that is, it can be done. It's just something that we are just asking just so that we can make sure that they have enough time to make arrangements in Florida and we travel to Texas.
All right, Ms. Ferguson, I need a jury trial date. How long is this case going to last?
I would say 4 days.
Yeah, 3 to 4 days would probably be my guess, Judge.
And Judge, the prosecutor is absolutely right. I just did sign on this case 10 days ago. In court this morning, he asked me to go check to see if these discs had been picked up, and they had not. I did not know they even existed until 10 minutes ago.
All right, Ms. Ferguson, I want this set for jury trial in the beginning of April.
I can do April 4th.
All right, we're coming back for jury trial.
We'll do the April 3rd, so that's on Monday.
All right. We're coming back for jury trial on April 3rd. That will be your plea deadline date and your jury trial date. I'm only extending the plea deadline date since you have a new attorney.
Thank you, Judge.
All right. So just sign up,
Thank you.
sign the reset form, and then you're excused. And Mr. Lozano, you need to be on time next time.
We have posted.
Yes.
It's more of a personal thing.
Oh, sure. Just give me a moment. Can you mute us, please? Mark Pena. All right, court is calling 2023 CR 0037, State of Texas versus Mark Anthony Pena. Could I have parties announced for the record for the state?
I believe this is a family violence case, is that what?
Yes.
Anna Ochoa Nelson for the state judge.
Defense.
Director Chief Mike Pena.
All right, so the defense has filed a motion to withdraw. Mr. Pena did not want to proceed without you being present, Mr. Ritchie. So, Mr. Pena, do you have objections to this motion to withdraw?
No, Your Honor.
Okay. Are you going to hire an attorney?
One of the means to us trying to get a court appointment.
All right, the court will grant the motion to withdraw. Mr. Ritchie, you're excused.
Thank you, Judge.
You're welcome. Ms. Ferguson? I needed an attorney appointed for Mr. Pena. Just have a seat. We'll get you an attorney. And Norma, I need a 1 month reset for that case as well. Mick Aguilera. He's not? Well, he's Deputy Mejia. Could you, oh, somebody, if you could have him, thank you. Could I have a month reset? Okay. Mark Pena.
I'm sorry, I'm just.
All right. Mr. Wood.
Top of the morning.
Top of the morning to you. Okay.
The reason.
I know there's a reason. You know, there's a lot of stress.
Charles Rubiola said, he said, you're laughing. Getting out of a kid in college. I said, let me get her out of college.
Oh, yeah, there you go.
That was
So who's
about
up on the wheel?
4 years ago.
Give me 1 second.
All right.
See if, Norma. See if Robert.
Oh, just 1 second. Let's start seeing if Callahan is available to come in. Just 1 moment.
Yeah, right, yeah.
Who's here on Brianna Kelly? Just let me take this up and then I'll take your matter up. Court is calling 2022 CR 11569W, State of Texas versus Brianna Kelly. And I need you in the center. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense. All right, we're here for sentencing. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
Any objections, state?
No.
Any objections, defense?
I don't have any objections that there's corrections, Judge.
All right, and what corrections?
So it says that she admitted to using in January and she denies that. And when we looked through all the notes and I conferred with both Mr. Escobar and Mr. Jurgens, since they were in and out. Mr. Jurgens and I found that the dates that she tested positive in January 18th of 2022 is the same day that it is alleged that she used in 2023. And I think it might just be a year mistake. She was here December 8th and admitted to the conduct, and we reset for PSI and put the tap. And she stopped using in December. You asked her if she would test clean that day, and she told you that she would not test clean that day.
All right, has she been tested today?
She has not been tested today.
All right, we're gonna do a UA today. If we do a UA today, what are the results gonna be?
I think I might come up positive for marijuana. But I had told my lawyer that it's.
Oh, we're gonna do a UA today.
And she has not been using the meth or anything else. It says also that she had been using Xanax. But she hadn't used that since before she went to jail in August.
All right, we'll do a UA today and we'll come back.
Okay, Judge.
Thank you.
You're welcome.
May I be excused from on the 399?
Sure.
Thanks.
Juan Avalos. All right, so this is set for jury trial. All righty, we will see you all tomorrow for trial. All right, Ms. Ferguson will give you a reset form so you can have it, so you'll know to be here tomorrow at 9. All right, thank you. And state on Mr. Avalos. There's no addition to the discovery, correct? Oh, this is family violence.
Family violence, no, we haven't got any additional discovery.
Okay, all right, thank you. We'll see you all tomorrow.
Yes, sir.
Okay, go ahead.
Yes. Yeah, that's good, please.
Steve Terrazas. And then I'll take you next. This is family violence. All right, what's happening with this case?
Just the first setting on this one. There's not an offer yet made. I know that Brittany would like to speak to the complainant beforehand. I am going through the case as we speak. I can't see any glaring gaps in the discovery at this point, but I know there's a child state video that I need to review as well. But that's for some time to do those things. And good morning, Your Honor.
Good morning. All right, is this allegation alleged to be a relative or something of that nature? Is there CPS records?
I don't believe there's a CPS record. It's not a relative.
Okay. All right, Ms. Ferguson, I need a 30-day reset on Steve Terrazas. All right, Ms. Ferguson will give you a reset form for March 9th, and then you're excused. And on that day, the state will be prepared to make you an offer.
Thank you, Judge.
You're welcome.
Question on this.
As soon as the reporter comes back.
Yeah.
All right.
The other case goes tomorrow, so
All right, and what is the client's name on that one?
that's the one that you want me to decide.
What's the name of it? All right, Mr. Pena, come forward. And can I see the file back on that? Mr. Pena, we're going to bring you back tomorrow. Yes, and you'll meet your attorney at that time.
I'll get to speak.
Yes, you'll get to speak to the attorney that's been appointed to you. The attorney that's been appointed to you by the system is Vincent Callahan. So if you'll get the reset form and just be back here tomorrow, okay?
Thank you.
All right, thank you. All right. Yes, what do you have?
I'm with Mr. Lede. I just got informed that they just bought him, but I just want to give you the amount.
Who is it?
JC Lede.
All right, did you ask them to pull the file?
That makes it very difficult, right?
Oh, it does. Ronald Collins. All right. Caroline, on this one, there's a motion to revoke pending as well. On, oh, no, I'm sorry, that's a different Collins.
That's okay.
Okay. All right, so what's happening with this case?
Well, we're conferring, Judge. I was conferring with Ms. Ochoa. I think she's going to review the file and convey an offer. I don't think we're gonna have a disposition today. So we're asking the court to reset the case. I believe this is our first setting.
All right, why were you late for court?
I was not aware that this was court. I mean, I was in the building. I just didn't know where I was at.
All right, so now you know where it is.
Yes, ma'am.
So I'm not gonna tolerate any more lateness, okay?
No, ma'am.
All right. All right, do you have all the discovery?
I believe I do, Judge.
All right, Ms. Ferguson, can I have a 30-day reset on Mr. Collins?
March 6th.
All right, we're gonna come back on March 6th. On March 6th, the state is gonna be able to make you an offer.
Okay.
All right, after you get the reset form, you're excused.
Thank you, Judge. March 6th is a significant day.
Oh, what is it? Is it the Ides of March?
You should know why. As a beloved Texan.
Oh, yeah. Well, you know, I love Texas, but you know, my home state is Louisiana.
I know that.
I still have my ties.
Born again. Oh, you can go to the, okay. March 6th is the day the Alamo was out.
Ah. Oh. Okay. Well, but it's still right there.
It is. It is.
Yes. Because see, then I'm thin. Deputy Laura should have never said that. So I take joy in other people eating the mini cakes. All right, Scott, Marcelino.
Yes, Your Honor.
He's trapped. All right, today is Mr. Marcelino's plea deadline date.
Yes, Your Honor.
All right, and counsel, you're on this side.
Sorry, Judge.
All right, thanks for addressing appropriately for court.
Thank you.
So how did your last name end up being Marcelino?
Marcelino is my first name.
Oh, so it's Marcelino Scott.
Correct.
They have it reversed on me. All right, so today is his plea deadline date.
He's not going to accept the state's offer, Your Honor.
All right, how long is this jury trial gonna last?
Probably not long, Your Honor. 2 days, I would ask for continuous violence case, Judge, and state attorney.
All right, Ms. Ferguson, recall this for tomorrow. We'll see you back here tomorrow. They'll give you a reset form. Are we ready on Brittany Brown? But most importantly, are the mini cakes delicious? I didn't make them. So I can't vouch for whatever ingredients they put in them. All right, so we're back on the record. In 2023 CR 0042, Brittany Brown. We were on the plea. So did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the entirety of the plea bargain agreement? I don't understand what's going on here.
But I'm not gonna be able to have my kids.
I'm not your attorney. So the only thing my job is to make you understand what the plea bargain agreement is. I've explained to you with regards to the meaning of an affirmative finding of family violence, and I always give people those instruction so they will know. Because many times when people enter pleas on the criminal sides, they have an impact civilly and in other ways. So with all of these family violence cases, when there's an affirmative finding of family violence, there are certain collateral consequences. One of those is you can't have a weapon. You can't possess ammunition. That's how it is in Texas. I can't tell you how it is in other states. But you can't have weapons, you can't have ammunition, and you can't be designated as primary custodial parent. So legally, you can't be designated as primary custodial parent. Those are the consequences of entering a plea, and those are the consequences of having an affirmative finding of family violence. Now, if you would like to, counsel, we can bring this back for tomorrow.
No, it's okay, fine.
All right, this is what I'm gonna do. I'm gonna have you all take a seat just to
No, ma'am,
talk it out
I
more.
do understand it, but it's just so, it's a horrible thing for, like, to have, this horrible, so I understand it, but
I mean, all the cases here are horrible. They're felony cases.
I thought it was getting reduced.
It's still getting reduced, but it's still, all these cases have consequences. Whether it's being reduced to a misdemeanor or not, there are consequences that flow from felony cases and consequences that flow from criminal charges. So what I'm going to do is I'm going to have you sit with your attorney, because I want you to, if you're planning on entering a plea in this case, I want you to enter it with a clear conscience and a clear understanding. So it appears to me, and I may be wrong, I'm making assumptions here, that you didn't know the consequences civilly of entering a plea in this case. And the fact that you're talking to me about, am I ever going to be able to possess weapons? Am I ever going to have my children? That's something that you need to discuss with your attorney, and it needs to be in a setting. I don't want to say without passion or objectively, because I know these are all personal matters, but it needs to be something that's thought about with clear head and something to think about. All right, so I'm going to have you all step back. And if your attorney feels like it's best that this be taken up tomorrow, we'll take it up tomorrow. I'm here all week. All right, so just step back and discuss it with your
I
attorney.
understand it, there's nothing I could do.
All right, just step back and talk to your attorney. All right, so are we ready to proceed on? Oh, no, I don't have that. Let me see. No. It's a Monday, but everybody has a smile on. All right, we're going to go back on the record in 2018, CR 0165, State of Texas versus Roland Lopez. Mr. Lopez?
Yes, ma'am.
All right, defense, I believe we were still in your case and shape.
We're going to call your next witness.
All right. Call your next witness.
Defense calls Lisa Ruiz.
All right, Lisa Ruiz. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. I'm gonna need you to make sure you speak up, state your name for the record.
Lisa Ruiz.
All right, defense.
All right. Ms. Ruiz, what is your relationship with Roland Lopez?
He's my boyfriend.
Do you live together?
Yes.
Where do you live?
1449 Chalmers.
Okay.
I'm sorry? 1449 Chalmers, sorry.
And how long have y'all lived there? A long time?
Yeah.
Okay. And generally speaking, has Mr. Lopez had the same job?
Yes,
Where does he work?
with the Freeman Exposition,
And how long has he been there?
I'd say like 4 or 5 years.
All right, so I'm gonna need everybody to stop whispering. Pretend like we're on the record And you're in the audience.
like 6 years,
Okay, how long have you guys been together?
probably about 8 years.
Okay. And do you have any children in the house with you?
Yes,
Um. And do you have any pets?
yes, we have 3 dogs.
Okay. And how much are you paying rent?
So we help his mom with her taxes and everything for about anywhere from like 900 to 1,000 maybe.
Okay. And Mr. Lopez's work helps pay for that
Yes,
and helps pay for food,
yes,
clothing,
yes,
taking care of the pets,
yes,
and pretty much everything, right?
yes,
Okay. Now, he's been on probation since 2018, is that correct?
yes.
And have you seen any changes in him since then?
Objection relevance.
All right, that'll be overruled.
Have you seen any changes in him?
Yes,
What have you seen?
he's a lot more relaxed, calmer.
Has he become sober?
Yes,
And what does that mean for your relationship?
if he wasn't, we wouldn't be together.
So you are helping him with sobriety.
Yes,
Okay. Now, when he does his probation meetings, are they on Zoom?
Objection, lack of person knowledge.
That will be sustained unless you can lay the foundation.
Okay. Have you been home when Mr. Lopez has had a Zoom meeting with probation?
yes,
And is that on the computer or on the phone?
on the phone.
Okay. Now, Mr. Lopez, is he a quiet talker or is he a loud talker?
He's a loud talker.
And now, when you say loud talker, does that mean he's angry and yelling or screaming?
Not necessarily, he just talks really loud.
So even if he's in another room, you can usually still hear him?
Yes,
Do you hear the other person or just him?
just
Okay. And if he were to yell or scream or anything like that, would you be able to tell?
yes,
Okay. In July of last year, do you remember him having to do a Zoom meeting?
yes,
Okay, do you recall any yelling, screaming, cursing, anything of the sort?
no,
Okay, and you definitely would have heard it even if he was in another room.
Objection
Yes.
calls for speculation.
Sustained.
You could hear his normal voice from another room.
yes,
So if he raised his voice, would you be able to hear? it?
Objection calls for speculation.
Sustained.
Have you ever heard him raising his voice in another room, say like during a football game or something like that?
Objection relevance.
Sustained.
Okay, do you remember any yelling, screaming, cursing, anything like that in a Zoom meeting in July of 2022?
no,
Do you remember any? Do you remember a Zoom meeting in November of 2022?
yes,
And same deal, he went to another room to do this.
yes,
Could you hear him talking
yes,
because he has a loud voice?
yes,
Could you hear the other side?
no,
Did you hear any yelling, screaming, cursing, anything of the sort like that?
no,
Okay. Now, last year between January and May, was Mr. Lopez on a very stringent schedule for drug tests?
Objection relevance. It's outside of the scope of this hearing room.
All right, that'll be overruled.
Was he doing weekly drug tests?
yes,
Okay. And As far as you know, that was supposed to end in May, is that correct?
Objection, calls for speculation, lack of personal knowledge.
Sustained.
Were you informed that it would end in May?
Objection, calls for hearsay.
Sustained.
Okay. Now, Mr. Lopez, he works, does he work regular hours or longer hours?
Mostly long hours,
More than 40 hours a week?
yes.
Okay. And does he depend on that overtime?
Objection, calls for speculation, lack of personal knowledge.
Do you depend on
Overruled.
that over-
I'm sorry.
All right, so here's the thing, everyone. When people ask questions and there's an objection, I make a ruling. If people don't want me to make a ruling on objections, then don't object. That's where we are. So the objection has been overruled and you can answer the question.
Yes,
Do you depend on that overtime?
yes.
All right, in November of 2022, did y'all change address?
No,
Did Mr. Lopez change job?
no,
Had he been arrested in November 2022?
no.
Ms. Ruiz, if Mr. Lopez were to go to prison today, what would that mean for you?
Objection, relevance.
Overruled.
It would be an income loss for me, for us.
Would you lose your home?
Objection, calls for speculation.
Overruled.
Maybe, yeah, yes.
Do you know how much longer he has on probation?
Objection, outside personal knowledge.
Sustained.
If she knows.
Sustained.
Are you proud of Roland for sticking to this probation and staying sober?
Yes,
Do you think he can complete this probation clean and sober?
yes,
Has he been a faithful worker and always bringing home money for the family?
Objection,
Yes.
overruled.
That'll be overruled.
yes,
Do you want this judge to send Mr. Lopez home today?
yes.
Ask the witness.
State.
Mr. Ruiz, how long did you say you've been with Mr. Lopez?
About 8 years,
Okay, and during that time, have you seen him struggle with drugs?
not necessarily, no,
No. Have you ever seen him use drugs?
no,
Okay. So you don't really know how he's doing with the sobriety, right? This is just from what he's telling you?
well, from living with him, I see him every day, he's normal to me,
Sure, so as far as you know, he's never used drugs.
around me, no,
Okay, so when you were telling his defense attorney about how you're proud of him for being sober, as far as you know, he's always been sober, right?
yes.
Okay. And the Zoom meetings that you were talking about, so I guess you were not present, you weren't in the room for those Zoom meetings, you were just in the house and could hear through the door,
Yes.
his side of the conversation?
Yes.
Okay. And you don't know personally whether he's been in compliance with his probation terms, right?
He has,
How do you know that?
well, what he tells me, but,
Okay, so he's told you that he's been in compliance, right?
yeah,
Do you know that he's had 3 motions to revoke filed against him since he's been on probation?
yes,
Do you know what a motion to revoke is?
yes.
What is it?
To revoke his probation, to send him to do the time instead of the probation.
Because he hasn't been in compliance, right? That's what the state alleges for a motion to revoke, right?
Yeah.
But as far as you know, I guess from what he's telling you, he's been in compliance the entire time.
That's also what I've seen.
Okay. Right, because you haven't seen him using drugs, right?
Yeah.
So if he tested positive, that would not be within your knowledge. You don't know of him using drugs, right? And you've seen him, I guess, you said he's been in compliance, so you've seen him providing proof of his address and proof of employment to his probation officer?
Yes.
When have you seen him provide that proof?
Usually after the meetings, he'll take a picture.
And I'm asking for a
I'm
specific.
sorry, excuse me.
Sorry.
Council, please slow down and please do not talk.
I'm sorry.
If you could please repeat your question.
Sure. Let's ask about a specific date. What day, or if you just know the month and the year, when did you see him provide proof of employment and proof of address?
I know, I want to say, I can't remember like a particular day or a month, but I know I've seen him take pictures and send them, email them to his probation officer.
Okay. Do you know who his probation officer was at that time?
It was, I think her last name was
How do you know that?
because he told me and I saw his paper. He told me.
What paper did he show you?
I guess it was like the court paper, the probation paper.
Oh, with his conditions of probation? Oh, so some other court paper?
Yeah,
Okay.
I know I saw her name on it. I remember her last name.
Well, that's it.
That's the further judge.
All right, thank you for coming in. All right, defense, call your next witness.
This time, defense press.
Yes, we have one rebuttal witness.
All right, call your witness.
The state calls Officer Priscilla Cisneros.
And Judge, I'm gonna object to that. So rebuttal witness, we've already had her chronologicals testified to by Miss Abrams. And at this point, she would be rebutting against herself for her own notes in the probation file. And I think that for rebuttal, that's not a valid reason to, the state can't rebut their own witness.
All right,
And
that'll
we're
be
not trying-
overruled.
We're not trying to, Judge. We're trying to rebut.
That'll be overruled. Call your next witness.
The state calls Priscilla Cisneros.
All right, Ms. Cisneros. If you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand and make sure you keep your voice up so that the court reporter can hear and I can hear. If you'll state your name for the record.
It's Officer Priscilla Cisneros.
All right, state.
Officer, what do you do for?
I am a community supervisions officer.
How long, for Bear County?
Yes, sir.
How long have you been with CSCD for Bear County?
4 years.
All right, and during that time, have you had cause to supervise the defendant in this cause, Roman Lopez?
I did. I've supervised him, yes,
When did you begin supervision of Mr. Lopez?
in October of
October.
2022.
Do you know who his probation officer was before you?
It was Officer Sarah Thatcher.
Now, in October of 2022, did you have contact with Mr. Lopez?
Yes, I had contact with him via Zoom.
Okay, and what happened on that Zoom interaction? I'm sorry, what day?
It was October 28th, 2022.
What happened during that Zoom?
I introduced myself. I informed the defendant that his officer no longer works for the department and that I would be taking over the case at the time being. I reviewed his conditions of probation and attempted to gather information in regards to his residence and employment. Defendant went on to state that he had been
Objection
transferred.
narrative.
Overrule. You can continue.
That he had been transferred to several different officers while he's been on probation. And that he had some speculations that he didn't agree with. And he wanted to meet with the judge to set a compliance hearing.
Did he clarify about what he didn't agree with?
He was adamant about the extension, stating that he should have been completed with his probation in July of 2022 and was not understanding why he still had to report.
And did you clarify that he was still on probation?
Yes,
Did you ask him for any kind of Well, actually, I'll move on. Did you have contact with him on November 17th of 2022?
Yes, we were scheduled for a Zoom meeting.
And did he appear at that meeting?
Yes.
Okay. What happened at that Zoom meeting?
He reported in on November 17th. That date, he stated that he was at work. I recall telling him if he had any proof of residence and employment. Once again, he became upset that he is still on probation, requesting again to speak with the judge. And also stating that I reminded him that he needed to submit a monthly drug test on that date. He stated he was at work, he could not attend the drug testing by close of business on that date because he was working a 12-hour shift, needed to provide a 24-hour notice to his employer. I gave him the option to submit the drug test within the 24 hours the following day. He said he couldn't, and I stated, okay. Upon review, I did notice that there was a pending MTR from September of 2022.
Okay, and so let me stop you. When you said you stated, okay, did you mean that it was okay to not, or did you convey that it was okay to not submit a drug test?
No, I did not say that it was okay for him not to submit a drug test. I just instructed him that he was either to submit today or tomorrow. If not, it would be reported as violation.
And as a part of the community supervision, do probation officers have the authority to direct a probationer on when to submit a UA?
Per condition number 2, all defendants are required to submit as directed by the courts or the supervision department.
Why is it important for the probation officer to choose the date of submission instead of the defendant?
Because given in this case, the defendant is on for felony of possession of controlled substance. If we allow the defendant to submit at his leisure, then chances are he can clean the system out and either submit a dilute or a negative drug test and not in fact monitoring him to see if he is randomly complying with his condition of sobriety.
Now, from your records, did Mr. Lopez submit either on November 17th, 2022 or November 18th, 2022?
No, he didn't.
And I guess on either of those 2 days, did he provide you proof of employment or proof of his current residence?
No, he did not. I did inform him to submit it via email. He had stated that he had submitted it to his previous officer. Once again, I had informed him that that officer no longer works for the department, and I needed to verify his current residence and employment. And the reason being was because he is on field visits monthly. And it was important. So I told him to email me. I recall giving him my email verbally. However, I did state at some point that I would be sending him an email. However, I don't recall sending him an email.
All right. But you do recall providing him your email address?
Yes, first name, last name.
And there's an allegation that he was not conducting himself in a proper and orderly manner on that Zoom visit. Now, you were the one that I guess organized that violation or submitted that violation to my office, right?
Yes.
What about his manner or conduct was not proper in your opinion?
In my opinion, I instructed him the moment he became argumentative, the moment I directed him to submit the drug test on either that day or the following day. And once again, he became argumentative because he stated that he should not be on probation at this point. As well as I addressed his monies, that he had not made any payment towards his probation fines, which he was currently delinquent. I believe it was like $4,000 some odd dollars. And I instructed him to make a payment, even if it was a minimum of $20 to stay in compliance with his conditions. He stated once again that he wanted to cut me off and stated that he wanted to talk to the judge. And I told him he would have his time in court. However, in the meantime, he needed to comply with all his conditions. He became argumentative, just stating that, I don't understand that, there's speculations on his case. And I told him I'm not gonna entertain the argument at that point in time. We were on meeting. And I was directing him at that point in time to comply with his conditions, giving him instructions to submit drug tests and pay for his probation fees, as well as provide proof of residence and employment, and that his following meeting, he would be informed.
What kind of reminders are probationers given to provide proof of employment and proof of residency?
Aside from verbal instructions from the probation officer.
Objection calls for speculation and lack of personal knowledge. These are not reminders sent by this probation officer.
Overrule.
The defendant is sent a 2-day notice prior to their scheduled appointment via text that they are required to submit proof of residence and employment at the time of their meeting.
And you said he didn't provide it at that November 17, 2022 meeting. Do you know when the next time he provided proof of employment and proof of residency was?
Since I've been monitoring him for October of 2022 and November of 2022, he has never provided proof of residence or employment.
Or do the probation conditions say that if he's provided it once, that's sufficient?
No, that is not sufficient.
How often is Mr. Lopez in particular required to provide proof of residence or proof of employment?
Monthly.
We'll pass on this, Judge.
All right, defense.
Give me a second, Judge. Okay, Mrs. Cisneros, what is the intention and goal of probation?
It's a program allowing defendants to, with our program, we redirect their behaviors that initiated their crimes. And hoping that they can be a contribution to our community. At the same time, ensuring the safety of our community and the citizens that reside in it.
Okay, so the goal is to, would you say the goal is to rehabilitate a client into becoming a functional member of society?
Yes.
Okay. And by functional member of society means someone with a steady job, steady home,
Yes.
steady family life,
Yes.
and able and drug-free,
Yes.
and contribute to society, pay taxes, all that good stuff, right?
Yes.
Okay. And as his probation officer, did you know that Mr. Lopez did have a steady job?
I was not provided any facts of that.
Okay. But you did read his probation file indicated that he had not had a change of employment in quite a while, right?
I have, but once again, each defendant is required to submit monthly proof that they are in compliance of condition. I believe it's number 3 or 4.
Okay, well, let's look at condition number 4. Can you tell me where in condition number 4 it says you need to provide monthly proof?
Obtain and keep gainful employment and lawful occupation and show proof of employment. Notify the supervision officer of any changes within 48 hours. You will tender any and all financial documents as directed by the courts or the supervision officer.
Okay, but does it say anything in there about you have to report monthly?
No,
Does it say anything about having to report every 3 months?
no,
Okay. And have you reviewed the chronologicals prior to this? Prior to today?
No.
Okay, were you aware that he submitted proof of employment, the same employment he's had since 2017? The last time was in July of 2022?
yes,
Okay, and correct me if I'm wrong, but you testified that he had asked for you to email him so that he could reply to that and provide you with the proof.
yes.
And you said you forgot to send that email.
I did not forget. I might have not sent it.
Okay, so you didn't send it.
No, I did not. send it.
Okay, and your name is Priscilla.
Yes,
Can you spell that?
Priscilla.
Okay. Is your name an easy name to spell? as compared to say. Jane,
No, it's not.
okay. All right, now. His main issue was he was confused about his conditions and his extensions. Because it differed from what he heard in the court, right?
I believe so, yes.
Okay, and so what he was asking for on November 17th and any other day was he wanted clarification on what his conditions were so that he could comply with them, and that's why he asked for a compliance hearing.
Yes.
Okay. And he believed that the judge said something different than what you as a probation officer were saying, right?
Yes.
Okay, and so can you understand why he might have been confused and wanted clarification?
No, because I did review the chrono that was submitted in July, stating that the defendant was provided all proof of his conditions signed. And he had stated to that officer that we are going back to that again. So he did have proof during that visit on, I believe it was July 13th.
Okay.
From Officer Bexar.
But he was confused on that date as well.
I was not there for that office visit.
Okay, so you don't know,
I don't know.
and you don't know anything about that office visit at all?
No.
Okay. So you can't say whether or not he was proper in conducting himself in a proper orderly manner in July. You can't testify to that at all.
I don't know.
Okay. Okay. In November 17th, 2022. Do you know if Mr. Lopez had a change in address?
Once again, he didn't provide me any proof of residence at that point in time.
Okay, but now, let's go back and review the terms and conditions of probation number 9A, okay? And does it say that he is required to provide proof on a monthly basis?
No,
All right, in fact, doesn't it say that he has to notify any changes within 48 hours? Is that correct?
yes, that is
So
correct.
if he did not have any change for this actual condition of probation, he wouldn't need to provide anything,
That is incorrect.
going by the plain language of condition number 9.
Yes,
So he would not, only if he changed job, address, or been arrested with condition 9 triggered.
yes.
Okay. Okay, now on September 16th, 2021, was there a field visit attempted on that day?
According to the chronos that were entered, yes.
Okay,
Based off of the condition that the defendant was ordered a field visit monthly.
okay. Give me a second. All right, I have a copy of your chronos here. Would you like to review?
All right, so ask your question. If she needs to refresh her memory, she can, but everyone just ask your questions.
Okay. So you just testified that you believe a field visit was attempted on September 16th, 2021.
Yes,
Okay. And did you know that there was a field visit conducted on 9/8,
of what year?
2021?
I believe so, yes.
Okay, and a field visit was done on September 4th, and it was successful, right? And then on September 14th, there was a field visit. Is that correct?
Yes,
Okay. But on there. Were you aware that there was no field visit conducted on September 16th?
yes.
So there was not one on September 16th.
There was no contact made with it.
No, there was no field visit attempted. Is that true?
Yes.
That no field visit was attempted on September 16th?
I need a refresh.
This is one of the pages of your
So what was your question?
was there a field visit attempted on 9/16?
Yes.
Okay. Here's the next page. You see 9/16 on that page?
No.
Okay. So I'm asking you again, was there a field visit conducted on September 16, 2021?
There was a field visit attempted, yes.
Where does it say that on there?
Not on here.
Okay. Every time there's a field visit, it does go into chronologicals, is that correct? So if it wasn't here, it means it didn't happen, right? So you agree with me that there's.
All right, here's the thing. Sorry to interrupt. Everybody, please keep your voices up. So here's the question. One of the allegations in this motion to revoke is that there was a field visit attempted on or about September 16, 2021. So did somebody from probation go out to his residence on September 16, 2021 to try to visit? That's either yes or no.
Yes.
There we go.
Okay. But if it was in the. Are you sure?
Objection, that's.
No,
Now you can ask it.
are you sure that there was a field visit on September 16th, 2021?
Our officers went out to the address on the 16th.
Okay. But they were there on September 8th and the 14th. As referenced in the chronologicals, correct?
Sustained.
Nowhere in the chronologicals does it say that they visited on September 16th. Isn't that correct?
It states right there,
Where,
September 16th.
which is reference to that.
Yes,
Okay, so there was no field visit on September 16th, is that correct?
that is correct. I apologize.
But there was one on September 14th, 2 days before.
Yes.
Okay.
All right, so here's the court's question. And please, everyone, listen to my question and just answer that question. In this motion to revoke, the allegations are that somebody from probation went to his house on or about the 16th of September 2021 and attempt to field visit. Did that happen or did that not happen? Did anybody from probation go out to his home on or about September 16th, 2021 to attempt a field visit?
No, Your Honor, I apologize.
All right, is there anything else of this witness?
Pass the witness, Judge.
All right, thank you. All right, so any other witnesses from either side? All right, number 2 is true, number 2 is true, number 2 is true, number 4 is not true, number 5 is not true, number 5 is not true, 9A is not true, number 22 is true, number 52 is not true. So,
Okay.
Mr. Lopez,
Judge.
here's the thing. You have a choice. I can continue on probation, but you're doing ISF, or either I will revoke you and give you 2 years. So if you want to discuss that with your attorney, you can. Those are your 2 options.
Yes, ma'am, I'll continue with probation.
Let's confirm first, sir. Yes. And
Okay.
Judge, I do need to bring up some administrative matters. Can you have a seat?
Sure.
Okay, thank you, Judge. I filed a motion. I need a ruling on my motion to quash allegation 22.
All right, that'll be denied.
Okay, and I do need to ask for findings of facts and conclusions of law.
All right,
I can follow up with another request in writing.
sure. You can follow that up in writing, but your client needs to make a decision and you have 10 minutes to make that decision. Either you're going to be continued and you're doing ISF or either you're getting 2 years. Those are your options.
And Judge, you
Two,
stated-
and two are true.
On the second two, Judge, there was no testimony whatsoever. on the
Two,
diluted sample.
and 2 are true. 4 is not true. 5 is not true. 5 is not true. 9A is not true. 22 is true, and 52 is not true.
Okay.
All right, so Jose Gallegos,
I have to ask for a directed verdict on condition number 2, because there really was no testimony regarding a diluted sample.
all right, so your client has 2 choices.
I agree.
Either he's
Judge.
going to ISF or either he's getting 2 years. I'm giving him till 12/10 to make that decision.
Just need to make sure I get my ruling.
Sure. I've already given you my ruling and I've told you what is true.
Okay, so you're
All right,
denying
thank
my directed verdict?
Yes, I am.
Thank you, Judge.
All right, who's here on Jose Gallegos?
Him, Your Honor.
Yes.
He is present. We had,
Report.
it's not having shown, but he is present with his wife. Today was the first day we got an offer,
Okay,
and the offer is something he would like to think about. So I'd ask the court to give us a reset to consider the plea. I don't want to commit to a plea at this point, but I believe that's where we're headed.
all right, always good seeing you.
Thank you, Judge.
All right, Ms. Ferguson, can I have a 30-day reset on Jose Gallegos, please?
You like us to sign something, Judge?
I'm sorry?
Sign a reset?
Yes.
Thank you.
What date? March 6th. All right, that will be your plea deadline date. It's always good seeing you.
Always good to see you. Thank you, Judge.
Sure.
We'll be actually worried about it.
And so does my mom. You're always in my mom's prayers. And Mr. Wood, make sure your client is on time for next time.
I'll tell you. Thank you, Judge.
JC Ludie. Yes. All right, what's happening with this case?
I could just confirm with the state we're missing, for Ms. Brittany to come back. It seems that the complaining witness is deceased in this matter, so
Okay.
we don't know if they're gonna be moving forward with the case or if they're not, so I need to confirm with Brittany on it. Do we have maybe like a week reset or work with you on it?
All right, just 1 second. Let me see something. State, do you know the date of birth of the complainant on this case? Because I'm looking it up and it appears that the complainant is deceased. Is the middle name Vincent?
Sorry, Judge, do you have a cause number?
It's 2022 CR 11874.
Is this a family violence case, Judge?
It is.
Okay.
Yes.
well, Wrong prosecutor.
All right, thanks. All right, so it appears,
I think we've already requested
Oh,
a death certificate
okay.
to ensure, Judge.
Okay.
And so I had a medical appointment again this morning, so I'm coming in late. I haven't had the opportunity to confer with him, but I can double check to see if there's something that we can do sooner, based on the information that we have.
right,
Just so you know, Judge, it's February 25th of 88.
all right, let me just do this real quick, just 1 second.
Okay.
That's-
February 25th, 1988.
Yes, Judge, it's the date of birth.
It's here. And I know you all need your documentation, but it's here on the system. And
Okay,
you can pull it up.
I
Hi.
conferred with somebody else this morning, so I haven't been able to talk to him.
All right, do you want to confer with him?
Yeah, I'm doing a couple things in between. but I'll get to him after that.
All right, and so we'll look it up. Brianna Kelly. Oh, your attorney's not here. Probation, do you have the UA results on Miss Kelly?
Yes, Your Honor. Her attorney said she would be back right at 12:20.
Okay. All right, we'll just have a seat and come back.
And
Okay. Are the parties ready on Brittany Brown?
I'm sorry, Judge, can you excuse Officer Cisneros?
Yes.
Okay, thank you.
Thank you. You're welcome. All right, are you all ready to proceed on Ms. Brown? And is she prepared to go forth or does she want more time? All right, we're going to go back on the record in 2023 CR 0042, State of Texas versus Brittany Brown. So Ms. Brown, I've gone over the plea bargaining agreement with you. Did you understand that to be the plea?
Yes, ma'am.
And do you understand the consequences of entering a plea with an affirmative finding of family violence? And knowing that, do you wish to proceed? All right, did you review the paragraph entitled waiver of appeal with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, there be any such motions?
No, Your Honor.
And counsel, did you understand that to be the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be 100 hours of community service restitution, the BIPP, a TAP evaluation, and follow all recommendations from the TAP evaluation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yeah.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence?
Yes, sir. At this time, state up for state exhibit number 1 and staff.
No objections, Your Honor.
Ms. Brown, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes, ma'am.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
He has had the problem, I guess, communicating, and understanding what is happening, but after explaining several times the situation, she understands everything, and we're asking that the court accept the recommendation from the state to place on deferred.
All right, what was your warrant for? In the police report, it says that when the complainant called the police showed that you had a warrant. So what did you have an active warrant for?
It had been for a failure to ID.
All right, state, can you see if there are any pending charges other than this case?
Yeah, there's a failure to ID. Oh, sorry.
Your Honor. There's a failure to ID. And that one is for the state, would be TIC.
It's not listed in the plea.
Judge, there is, but we can, I can enter a dismissal. I think you just give me a couple months to fill out a dismissal.
All right, thank you. All right, are you employed?
At the moment, no, I'm not.
How do you support yourself?
I'm living with family right now.
What family is this?
My mom.
All right, and Child Protective Services were called. Is Child Protective Services involved?
Yes.
All right, this is what the court is going to do. 2 years deferred adjudication. There's an affirmative finding of family violence. Well, let me strike that. The state is requesting that actually you have a conviction. What the court can do is you can have a conviction. That's what you bargained for, or either I can give her deferred adjudication.
Legal. It was for deferred adjudication you asked for.
All right, if the court were to give you deferred adjudication, if anything were to happen and your probation were revoked, you could end up with potentially 1 year in the Bexar County Jail. What the state has offered you, if you were to not do well, you could still end up with 1 year in the Bexar County Jail. So which would you prefer? Would you prefer conviction or deferred adjudication?
Conviction.
All right, court will sentence you to 1 year in the Bexar County Jail.
No, miss.
You said a conviction.
Oh, I thought, okay, I'm sorry. Oh my God, no.
So are you
I thought
asking,
you meant like on the record.
are you asking for deferred?
Yes, ma'am.
All right, with the deferred adjudication, the court could sentence you to up to 1 year in the Bexar County Jail if you are unsuccessful. Do you understand?
Yes.
And up to a $4,000 fine. Do you understand?
Yes, ma'am.
And are you requesting that the court give you deferred adjudication?
Yes.
All right. Court will sentence you to 2 years deferred adjudication. There's an affirmative finding of family violence. There's to be no contact with Tagai Buzu. If there are some kind of child custody arrangements that need to be made, you'll need to make those through a third party. If you wish to have contact with him, he'll have to come in to court, and I'd have to hear some evidence with regards to that. There's to be 100 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. I'm going to request parenting classes. CPS should give you parenting classes, CPS compliance. Probation, if CPS is giving her parenting classes, then she can, then the court will accept parenting classes from CPS for her. There's to be the BIPP course, TAP evaluation, and whatever the TAP comes back with, we'll start with supportive outpatient treatment. And again, if CPS is giving her alcohol treatment or drug treatment, then CPS can do that, and that'll be acceptable. Regular UAs, I'm going to want field visits at least 1 time per month until further notice. Regular reporting in person or by Zoom. Proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. Probation, is there anything else she needs? Is there anything else you need from the court in order to be successful? Anything else you need, Ms. Brown? I can't understand that.
You said, what did you say about minors?
You're not to have any employment.
Oh, like a daycare. Okay.
Yes. And you're to follow all CPS compliance rules. Did you review this document with your attorney entitled Trial Court Certification of Defendant's Rights to Appeal? Did you understand it and did you sign it? Did you review that document with your attorney?
I'm sorry.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yeah.
All right, good luck to you. Thank you.
Thank you. Huh?
Who's here on Jacob Moya? The attorney for Jacob Moya. Okay. Who's here on Roland Lopez?
That's me, Judge.
All right, what is your client doing?
My client has indicated he'd like to stay on probation.
All right, Mr. Lopez, you can come forward. We're back on the record in 2018 CR 0165. The court will deny the motion. Alter and amend conditions to extend for 1 year. ISF state, and he's to remain in custody until transfer. There will be field visits at your house, and probation. These field visits will be on the date that you schedule them. So there will be field visits 1 time per month until further notice. There is to be the UA hotline until further notice. And I want him tested at least once a week. And if you want to, you can do that, or you can do the patch. So he can either do the patch, that'll help him with his employment, or either he can do the UA hotline. Do you understand?
Yes, ma'am, I do.
And you're on zero tolerance. I don't do zero tolerance normally, but since there seems to be some concern, so this is what zero tolerance means. If you violated any conditions of your probation, then you will have violated the zero tolerance policy. Do you understand? So if you don't report, that's a violation. If you don't do your UA, that's a violation. Do you understand? All right, good luck to you. Yes. Yes. All right, who's here on Joseph Garza?
I am.
Mr. Garza, come forward. All right, so today is your client's plea deadline date. What's happening?
Judge, I confirm with the state. Once I try.
All right, how long is this trial going to take?
I would imagine maybe 3 to 4 days.
All right, we'll see you tomorrow. Ms. Ferguson will give you a reset form. So you'll be here tomorrow for jury trial. All right, are we ready on Brianna Kelly? All right. I'm being told that your client is positive for meth, amphetamines, and marijuana.
That's what I understand as well. I was asking if there was a list the CLO was trying to get about how long those may stay. I don't know if they could stay in from December.
No,
We hadn't
they
gotten
don't. All right, we're going to go on the record 2022 CR 11569W, State of Texas versus Brianna Kelly. We're back on the record. All right, the court is going to follow your agreement. The court will find you guilty, sentence you to 2 years in the prison, suspended and probated for 5 years. This will run concurrent with County Court Cause number 691768. Taking consideration 2022 CR 6341B, grand jury number 768492. There's to be restitution and no contact with the following people. And that's restitution, if any.
Judge, I think that part of the reason we had the PSI was to see if there was restitution, and all of the victim impact letters came back unanswered.
All right.
They tried to contact everyone, but no one responded.
State.
As far as I'm aware, I don't think they've been contacted so far. Judge.
All right, so there's no restitution, state?
as far as I'm aware, at this moment, but we would just ask if they do come forward later on, if they can get the letter, we can address that matter at that point.
I mean, we're addressing it now. Any restitution?
But no, not as far as we're aware.
All right, there should be no contact with Anna Velasco, Draco, Drekko, Jackson, Jaxon, Lorena, Lareina, Garzakowski, Grzegoraewski, Arturo M. Saenz, Sanez, Samuel Estrada, Cecilia Gonzalez with a Z, Marivel, Marivel, Gonzalez with an S, Damon, Dijimon Woods, Nyla, Nilah Rojas, Damian Reyes, Ridgemont Properties, Metropolitan Construction, Walmart, there should be regular reporting by Zoom or in person. Proof of employment within 30 days of release from custody. There should be no employment as a home health care provider or with minors. 150 hours of community service restitution, 40 of those hours be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. Do you have any children?
Just one.
What are their ages?
He's 8 years old.
All right. Parenting classes, is Child Protective Services involved?
No, she doesn't live with me.
Okay. Parenting classes, once you complete the remaining of those parenting classes, the court will waive the remaining of the community service hours. I'm going to want field visits upon release 2 times per month, and those can count as visitation. Cats 1 and 2. Cats 1 and 2 is to tell you don't steal. And the MRT is something that everybody should have learned in primary school, which is do the right thing. All right. And she's going to be taken in custody today. I'm going to want a referral to felony drug court. If felony drug court does not accept her, then she's going to safety. And that's while in custody. Probation, is there anything else she needs? Is there anything else you need from the court?
No, what's going on today?
Oh, you're being taken into custody today.
Can I ask how long or for?
They'll let you know, but felony drug court should have an interview for you fairly soon this week. We're going to do the UA hotline upon release. Thank you.
Okay. Judge, I just want to make sure. So if she gets accepted to felony drug court, she will not have to go to safety.
No.
Okay.
Well, I say no, and I mean no, not necessarily. If she's accepted to felony drug court, then felony drug court will make the decision of whether or not she goes to safety.
Okay.
So they still may order it. Once someone's accepted into felony drug court, I'll allow them to set the conditions.
Okay. And you think that the turnaround time would be by the end of the week or they'll?
Oh, felony drug court, they'll have an answer. But if she's over at felony drug court saying, I'm going to be negative and all of that, they're not going to accept her.
Okay. Thank you, Judge.
You're welcome. All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. You understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. You're gonna have to do better. Israel Elizondo. Hello. Hi, you're on this side.
Yes, Judge.
All right, what's happening with this case?
We have the records properly, correctly. They came through just now. We are finally able to read them all. And today I am ready to sign a discovery acknowledgement. Hallelujah.
Okay.
If you would like to give us another plea deadline, that would be ideal. If not, I mean, I'm confident that we have the discovery.
All right, so when you guys were here on January 17th,
Yes, Judge.
well, let me go back. On December 2nd, I was told school records were received. And then on January 17th, I set this for a plea deadline today because I was told that all discovery records have been received.
And they were blown up in such a way that what was written, half of it was cut off.
Ah.
So I could not read but half.
All right, Ms. Ferguson, I need a 3-week reset.
It could just not be the week of March 5th. I am first in trial in Hayes.
Okay.
I'm number 1 on their docket.
All right, Ms. Ferguson. All right, we'll be back on March 2nd. That's your plea deadline date.
Thank you, Judge.
All right, thank you, Ms. Ferguson. We'll give you a reset form.
And would you like me to sign that discovery acknowledgement, Judge?
Yes. Who's here on Jacob Moya? And probation, there's no application on this case. Court Tech, I'm sorry. Fernando, I'm sorry.
No problem.
Oh, no problem. Court is calling 2023 CR 0061, State of Texas versus Jacob Moya. Can I have parties announced for the record for the state?
Debbie Cruz, on behalf of the state, Your Honor.
Defense?
Tony Adonis on behalf of Mr. Moore.
Are you Mr. Moya?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Moya, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, ma'am.
State, are you proceeding on the indictment as presented?
Your Honor, we are proceeding on the offense alleged. However, we are waiving the repeat offender allegation.
Any objection?
No.
All right, Mr. Moya, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand what you're charged with is burglary of a vehicle with 2 or more convictions? That's state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine.
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court doesn't have to follow that. If for any reason the court doesn't follow it and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into an agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, sir.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Moya, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, State is waiving the enhancement allegations. There's to be 6 months in the state jail facility. No applications. They will take in consideration County Court Cause number 701618. Did you understand that to be the plea?
Yes, sir, with, I think, okay, yes, sir. He's
Defense?
asking if the court will give him credit for time served. For the time he's already served. Yes, Your Honor, that is my understanding.
State?
Yes, that's our understanding.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
No.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Your Honor, this one, the state introduces State's Exhibit 1 and all of its attachments.
No objection.
Mr. Moria, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes,
Anything you wish to say on behalf of your client?
he's accepting responsibilities, just wanting to move forward. He seems to be doing very well right now.
Is he doing well because he's in custody?
No, just he was doing well before. He had some issues with those, and he seems to be doing well since this offense has happened.
Why do you keep breaking into people's cars?
Garner, I wish to think that's something that I grow out of. I
What
think
do
it
you-
was just an immature thing.
No, I mean, that's not a sign of immaturity. There are a lot of people who are not breaking into vehicles and
Yes.
taking things that don't belong to him.
You're correct.
So why are you doing that?
Honestly, I don't have a logical explanation.
How old are you?
I'm 26, just turned 26.
Do you want to spend the rest of your life in custody? Do you want to go to prison?
No.
Then why do you keep doing this? People work hard to have what they have. That person's car that you broke into, now they, who knows, maybe they had to get a new car. People going around using screwdrivers to break into people's cars. People don't like that. That's how people end up getting shot. And when I say people end up getting shot, I mean the person who's breaking into somebody's vehicle.
I think almost that's what actually scared me to not want to do that no more, because that day I experienced that when he came out with a shotgun. So with that being said, I don't think that's something that I will be doing.
So what are you planning on doing with the rest of your life?
He has a job. He was working when he got picked up on this case.
I've
I've spoken to his employer, so Jason.
and he, with my partner, Jason, he owns a landscaping business. I was doing landscaping fencing. Prior to me getting arrested, I was in Austin working a job with him, for him. That's a promising career, I could say, that I had found and that I plan on moving forward with, and just pushing as far as I can go with that.
All right. Court will follow your agreement, sentence you to 6 months in the state jail facility, give you credit for any time served, taking consideration 701618. Is there anything else with regards to sentencing from either side?
Nothing from the state attorneys.
Nothing from the defense, Your Honor. Thank you.
You're welcome. All right, next I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you. Don't come back here for this foolishness. You understand?
Yes, ma'am.
All right, have a good one.
Yourself.
Thank you.
Thank you.
Maybe
Yes. All right, who's here on Antonio Azazua? No.
Ability or position.
And on his case, Judge, I've looked into the that issue. I need to look into alternative routes of, I don't say resolving this case or proving this case, I should say.
So how much time do you need?
If you give me 2 weeks, Judge, we requested the death certificate, I think on the 2nd.
Mhm.
But I also need to see if we have contact with some of the witnesses as well.
Okay. All right, Ms. Ferguson, I need a 2-week reset on Ledehe.
I can do February 27th.
All right, so we'll come back on February 27th.
Yes, sir. Yeah, good.
Yes, after the reset form is signed. All right, who's here on Donald Burnett? Yes. Where's Burnett?
He's here, Judge.
He needs to come forward. What's happening with this case?
Your Honor, Mr. Wolf and I finally met to be able to talk about this case. The defendant is a witness in the Curtis matter. It's also before the court. What I would like, because this is his first indicted setting, if the court can give us a reset where Mr. Wolf and I can arrange for an interview and maybe able to come back to the court with an agreement as anticipated.
All right, when is this happening? Does he have all of the discovery on this case?
I pushed it forward to Mr. Wolf in advance once it was indicted. To my knowledge, yes, he does anything that he wants. I've also shared the broader discovery from the entire file and other arrangements the state has made with other witnesses. But anything that he wants or seeks, I will provide.
All right, Ms. Ferguson, I need a 30-day reset for a plea deadline date. All right, your plea deadline date is going to be on March 9th. After that date, the court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plead open to the court. Do you understand? All right, thank you. Ms. Ferguson will give you your reset form. Who's here on Cameron Lawrence?
I'm here, Judge. That's an off docket matter. I've confirmed with the state regarding this. He is currently in federal custody. We were here about a week or two ago.
Yes.
On a setting, and we noticed that he was transferred. What his federal lawyers indicated to me that he was picked up by the US Marshals and is technically still in primary state custody and is not receiving credit for time and will not receive credit for time as he deals with this federal sentence. And so he asked if I could do something in regards to try and get him released from state.
Okay, I'm not going to grant him a PR bond.
Well, so I don't know how we would be able to release him from primary state custody. He's currently in federal custody.
Okay.
And so he's not going to be released. It's just that.
No, I understand, but I'm not going to grant a PR bond for an aggravated case. So if you all want to come up with something else, the court is willing to consider it. But, and I know he's in custody and federal, and I understand what you're saying, but I'm not going to grant a PR bond for.
Well, my thought was that if he was granted a PR bond, he'd be released from state custody, and then he could be revoked on that PR bond, and then he would then be back, I guess, technically on a state hold. However, he would then be in federal custody, in primary federal custody.
All right, if you guys want to confirm something else, the court is willing to consider it, but I'm not granting a PR bond.
Okay, then. Well, so with that being said, we were, I guess you had scheduled his case after the trial setting in federal custody. which is in March, and so we're set in April.
Well, I will tell you, I guess this has been, let me see. I think this has been newly indicted
That's correct.
because the only thing I have on this docketing sheet is a January date.
Correct.
And so I have the date for his case here, April. If you want to set it sooner than that, then. Just
Well,
like the court now.
I think he would prefer getting his federal case started,
Okay.
as you would be aware.
All right, who's here on Fernando Rios?
State probation and I have an agreement to continue him on probation if you are so inclined.
Well, I mean, where is he? Is this being heard?
We were hoping that it would be yes, Judge.
Oh.
If you like, can do a probation.
Okay, thank you. All right, and the people who are not here for their jail cases, they go back and they'll be recalled for tomorrow.
11:01. I think it's 2022, but I know it's 11:01. Ask them.
Mr. Wilson, have you called your attorney? All right, we're gonna end up, Ms. Ferguson will give you a reset form. We'll see you back here tomorrow for jury trial. All right. Oh, no, I understand. Just give us a second so Ms. Ferguson can give you a reset form. So she'll call you up, okay? All right. And could I see the files you have left remaining? Have you all conferred on this? On Fernando Rios?
You just have to.
Okay. All right, Ms. Ferguson on Jalen Collins. He's been sent back, correct? Has Jalen Collins been sent back? Okay, so we'll recall that tomorrow. All right, state on the probation docket. Jalen Collins is going to come back tomorrow.
Yes.
Collins.
Is that for native? This one?
Yes. Yes,
He's actually just started a capital in the 37.
Oh, he has?
Yes, ma'am.
All right, so,
I just have to, Trish.
all right, so what date?
I don't know how long the capital's gonna take.
Let's just recall this for next month then.
I can do the 21st.
All right, so everyone, correction, Jalen is going to be on the 21st.
Judge Cornelius is also on that Wilson case.
Okay, and Mr. Wilson, can you come forward, please?
He also has another client.
All right, we're going to call you back. Instead of the date I gave you, we're going to have to call you back on the 23rd. You said 23rd or 21st? 21st. Your attorney is in a capital murder case. So, and which court is that, Norma? Oh, it's right across the hall. You can go over there and watch him work if you want to. All right, so Ms. Ferguson will give you a reset form and we'll see you back on the 21st.
Yes, ma'am. Thank you.
You're welcome.
Yeah, we can have a seat for now.
And you always dress appropriate for trial. Who is that with you?
That's my mother.
Okay, I know it's you who's doing that, and I want to say I appreciate that. It's always the moms. All right, Anthony Cruz. Mr. Cruz, who's your attorney? All right, so we're going to bring you back on the 21st. Your attorney is across the hall trying a capital murder. If you want to go next door and sit in and watch him, I'm sure you're more than welcome. But Ms. Ferguson will give you a reset form. All right, just have a seat. We'll call you up.
Hey, Judge.
We haven't had a chance to look at this.
Okay, just give me 1 second.
Sorry for that.
Oh, no problem. No. Diamond Danzy. Who is your attorney? All right, any update on Mr. Simpson?
No, ma'am.
All right, we're gonna give you a reset. We'll see you here tomorrow. Are you employed? All right, what is your work schedule?
Right now, see, my mom just had surgery. I don't have primary, so Mondays and Tuesdays I go in late, and then Wednesday, Thursday I do.
On Thursdays, you do 1 p.m.?
PM to 10.
All right, Ms. Ferguson, let's call her back for Thursday, and you need to let your attorney know to be here.
For this
Yep.
Thursday, I'm actually out of town.
Where?
I'm supposed to be going to San Diego to be inseminated for services.
Ah. Well, far be it for me to interfere with that. No, I mean, that's what's happening. So when do you leave for that?
Thursday evening. But I'm off. My daughter has a doctor's appointment. I can move that stuff around.
No, I mean, your daughter needs her doctor's appointment. And your work schedule tomorrow is what?
I go in at 5.
All right, just give us a moment. Norma, see if you can get her attorney here. And who is here on Sergio Garcia? And where is Sergio Garcia? Is he in custody? All right, that'll be recalled for tomorrow. All right, Norma, you got that?
I think so.
All right, that's Sergio Martinez Garcia. And then Roland Garza, is that person in custody?
Yes.
All right, and Norma, Roland Garza, recall it for tomorrow.
Judge, on that one, his attorney was supposed to come in the afternoon.
Oh,
To view the DVD.
okay,
We had said for him to do it here in the courtroom,
yes,
so he's supposed to be here by 1:30. Or after 1:30.
all right. So make sure, call him back if you let him go. I do remember that. Bernardo Huerta.
That's very ominous.
All right, on that one, Bernardo Huerta, that's to be recalled tomorrow. And then Joe Anthony Jimenez. It says here that this person is awaiting federal trial. And I'm trying to see what page he is on.
He's on page 14.
All right. All right, so he's awaiting federal trial. Call Robert Porter and have him call over. Yes. Yes. Oh, he'll get credit for any time that he's been in custody. Yes. He'll need an attorney to do that. Yes. All right. Fernando Rios.
I was just thinking, I got stuck in the elevator today with another attorney. And he was like, don't worry, I will go report it because I know how. And I just was sitting here thinking to myself, well, I'm glad he knew how because I have no idea who to tell, but I got stuck in the elevator today. I hope like that they fixed it. But
Oh,
yeah,
wow, you didn't have your cell phone with you? I've been stuck in the elevator before.
it like, we were stuck for a few minutes and then it popped us open. But
Oh.
yeah, I was just like thinking about that. Like, I don't even know who to tell.
Well, you know, I was reading this series of novels called the Cal Leandro series. And you know, they say elevators are just still coffins, so you really shouldn't take those. You should take the stairs. Just throwing that out there for anybody who's leaving here to take the elevator.
Sitting is the new smoking, Judge.
And the elevators here are always dicey.
They are.
All right, court is calling 2022 CR 1101, State of Texas versus Fernando Rios. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Alice Warburton for Mr. Rios.
Are you Mr. Rios?
Yes, ma'am, I am.
Showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, I did.
Are you the same Fernando Rios Jr. who was placed on community supervision in 2022 CR 1101 for the offense of driving while intoxicated third or more on April 14, 2022 for a term of 6 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 2, on or about the 12th day of August 2022 in Bexar County, Texas. The defendant, Fernando Rios Jr., did then and there submit an invalid sample for drug testing in that the sample submitted was diluted in violation of condition number 2.
How do you plead to that? True or not true?
True. Your Honor, state waives all the violations.
And the
Any
defense-
objections?
No objections, Judge. We have demonstrated to the state that much of that MTR, oh, yes, Judge.
All right, any objections?
No objections, Judge.
Did you understand by pleading true to violation of condition number 2, the court can find it true, grant the motion, sentence you to 4 years in prison and up to $1,500 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there an agreement?
There is, judges, to deny the motion, continue with IOP treatment and alter and amend for monthly UAs with 0 tolerance and to hold safety in abeyance.
Is that the agreement?
It is, Judge.
All right, Mr. Rios, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. State your name for the record.
Fernando Rios.
All right, so what's the issue with you on probation out of this court? Like, why are you not successful? Why am I seeing you on this motion to revoke?
Because of these diluted UAs, Your Honor. Unfortunately, I do drink a lot of water and that's really the sum of it. I'm sorry. There has been success since my being in this courtroom. I actually have 14 months of recovered sobriety.
Congratulations.
I wanted to show you this.
Oh, I love to see the chips.
I'm sorry.
No, come forward. Oh, thank you. Well, I am happy and excited for you. Life is so much better when we go through it clean and sober, right?
Yes, and I'm actually working with other sponsors.
Awesome.
Like,
You have other sponsors?
I have a lot to be thankful for. So the fact that this was brought up was kind of a slap, not a slap in the face, sorry, but something I wasn't expecting, but just saying.
Yes, Judge, we've been able to clarify some of some of that MTR is not. We were able to clear up with the state that some of those allegations are incorrect and, you know, the diluted, they are. I've asked Mr. Rios, you know, he is adamant that he's sober and living a better life. I asked him, I told him before we even came here today, I said, you do realize that the judge may have you go back and take a sample right here and there. And he said with 100% confidence, he's happy to do that. He is 100% sober. And Mr. Rios, will you clarify to the court, have you ever tested positive for drugs or was it only an alcohol problem? I don't remember what that is.
Sorry, I have never tasted drugs. I've never tested positive for drugs. It was only alcohol.
And I always tell people alcohol is drug.
Yes.
Oh, yes.
Yes,
but
Judge.
yes, I have tested positive for alcohol. That is no longer in at all my nature. The craving is gone and I'm living a wonderful, lovely, sober life.
Okay, and have you been staying in contact with your probation officer?
I have, yes.
All right, and how are you on this DWI victim impact panel?
I have the certificate, yeah, I have the certificates as well.
No, you're doing great. All right, so you've done that, and how are you doing with your community service hours?
Community service, working on starting that with my new appointed probation officer.
All right, and the DWI intervention program?
I did that as well.
Okay, all right, awesome. Well, congratulations.
Oh, thank you.
Oh, thank you. I appreciate that. I try to make sure that if people are on probation, they're successful at it. I want you to be successful when you're on probation.
Well, no, I just think of what you told me during the last time you had seen me in court on the ruling was
just that you want me to do better. And I'm doing amazing. And I thank you.
Oh, thank you. You're welcome.
He's gotten a job since he's been on probation. He's doing great.
Oh, wow.
Yes, withholding job financially getting there, but I mean, who doesn't like ramen here and there?
Yeah, there you go.
But I'm doing the best that I've ever done, and I can't wait to see what else the world has to offer, even while on probation.
All right, so this is what I'm gonna do. I'm gonna deny the motion, alternate amend conditions. I don't understand the intensive outpatient treatment request. Okay, you're currently in IOP?
Not to my no.
Is he currently in intensive outpatient treatment or did he complete it?
No, Your Honor, it's not in business outpatient treatment at all.
Okay,
Sorry, that was a part of probation.
all right. So what we're gonna do then, do you feel you need intensive outpatient treatment?
I don't, Your Honor.
All right, so what we'll do is we'll just keep an eye on it, but the record's gonna reflect that you're telling me that you don't need intensive outpatient treatment, you're doing your own treatment, so I hope it doesn't happen. I don't think it will happen, but if you come back here and you say, I need intensive outpatient treatment, because I write everything down, I'm gonna say that he said he didn't need that, okay?
No,
I know you're doing, but you know what? I will tell you this, I'm not gonna order it, but I had put in the original conditions that he was to do sober meetings and intensive outpatient treatment if not accepted in felony drug court.
Yes, Your Honor. So records indicate that the felony drug court referral, he was accepted, however, he did not want to participate.
Okay,
Just my meetings, so.
okay. Okay, so what we'll do is we'll do outpatient treatment then instead of intensive.
Support it.
Yes.
And Your Honor, can we have some direction as far as the diluted UAs, if it's going to continue to drink a lot of water?
I was
or-
going to
Please,
say,
if you, yeah, so I can avoid
no
that.
more Stanley Cup challenge, that like water challenge. It's the rage to drink.
How do you want to
water.
address that probation? I mean, is there something else test that he can take?
We could do hair follicles.
All right, so,
Or swab.
all right, so here's the thing. Let's do this, because I hate to take people's hair,
Mouth swab.
because you're pulling it from the root. That's pain. I don't care what anybody says, that's painful. That's happened to me and it hasn't been due to a UA. But that's happened to me on accident and it's painful. So this is what we'll do. Let probation know if he gives a diluted sample, then do a swab as a backup or either the hair follicle. So they have my permission to do that. So if you want to lose your hair, then it'll be a dilute. But I tell you what, if it's going to be a dilute and you go over to probation and you shave your head, then I'll know there's something else going on. All right, so we're going to do supportive outpatient treatment. He can continue with the UAs. If diluted, then you can do oral swab and or hair follicle. So if there's a dilute, it's going to be up to probation and probation will have the choice. They can then either do the hair follicle or they can do the oral swab. You understand?
Yes, that's perfectly fine.
All right, probation, is there anything else?
No, Your Honor, I believe he has an active warrant.
Oh, yes, Judge, we would ask that you recall his warrant.
State any objection?
No, Your Honor.
All right, we'll recall the warrant. Is there anything else?
Nothing further from the defense. Judge.
Anything else you need from the court?
No, you've done amazing.
Oh, do you guys hear that? I'm being told that I'm doing amazing. You're so welcome. And when you leave here today, I know you're happy that you're not going to jail, but when you're in your sobriety, you have to stay vigilant. Okay? All right, good luck to you.
Thank you.
You're welcome. Joseph Garza?
Yes, Judge.
Yes.
Judge, you recall that for tomorrow, but
Yes.
we have, we have an agreement that the state has made me a different offer.
Okay.
But my client is a single parent, so he needs some time to make arrangements for his daughter to stay with his mother.
All right, so
We're gonna ask-
TDC.
Oh, well, he can enter his plea today and then we can recall it for a different day.
Yes, Judge.
All right.
I'm on the phone.
All right, is there? Yes.
Yes.
Bernardo Huerta. Oh, I thought you all had sent Mr. Huerta back. All right, what's happening with this case?
Good morning, Judge. I think I'm gonna have a discovery acknowledgement for you, but I did want to just make a record with my client that he understood what the state's offer was, that he's rejecting that, and then.
All right, well, I will step out and let you put that on the record. Okay.
Great. And then I think we just need to get a trial setting.
All right. So when was the offer tender?
That was today, Judge.
All right, Ms. Ferguson, can I recall Mr. Huerta back in 2 weeks for a plea deadline date? All right, we'll be back on February 27th. At that time, you can accept or reject the state's offer. If you choose to reject the state's offer, the court will not consider any plea bargain agreements without good cause. Otherwise, you have to plea open to the court. Do you understand? You have any questions about anything?
As far as about the charges or anything?
I mean, any questions? And you can ask a question. And if it's something that your attorney should answer, not me, I'll let you know.
I'm just kind of stuck on the fact that the charge, because it's a.
Judge, I'm gonna advise my client not to discuss the facts of the case or his opinions of the facts of the case, and to exercise his Fifth Amendment right to remain silent.
Okay. What I can tell you is you're charged with an aggravated case. So is it aggravated robbery?
Yes.
All right, so it's an aggravated robbery. So that's a first degree felony. I don't know any facts of any of these cases unless, police reports are presented to me and unless I hear from witnesses. The only thing I know so far is what you're charged with. You understand?
Yeah.
Your attorney is saying that she doesn't really want you to discuss with the court what you believe the facts to be. So please don't discuss those.
Okay.
So do you have any questions about this process?
I guess not.
All right, so I'll step out briefly so that you can put on the record whatever you wish to put on the record.
Thank you, Judge.
All right, you're welcome. Yes. We're back on the record in 2018 CR 0165, State of Texas versus Roland Lopez. That parties announced for the record for the state.
Jason Garahan, Your Honor.
Kurt Hoppy for the defense.
And are you Mr. Lopez?
Yes, ma'am, I am.
All right, Mr. Lopez, the court gave you options, which I can't do that in every case, but some cases I can. And I asked you if you wanted to go to ISF or either the court would sentence you to 2 years in prison. My understanding is that you changed your mind and you wish to withdraw, or I'm sorry, you wish to have a motion for the equivalent of a new trial or reconsideration. Is that correct?
Yes, Judge.
Any objections from the state?
No, Your Honor.
Defense?
No objection, Judge.
All right. And so are you asking the court to sentence you to the 2 years prison?
Yes, Judge.
Are you waiving your right to appeal?
Yes, Judge.
All right, the court will sentence you to 2 years prison. Give you credit for any time served. There's to be a $1,500 fine, time and money to run concurrent. Restitution of $57 to SAPD. Did you ever pay that restitution?
Ma'am?
Did you ever pay the restitution to SAPD of
They said it
$57?
They said it wasn't within the probation fees or whatever it was.
I believe it has been taken care of, Judge.
Probation, has that amount been paid?
Yes, Your Honor.
All right. Well, the court will note that the restitution is satisfied. So the court will sentence you to 2 years in the prison. Of course, revoking you, give you credit for any time served. There's a $1,500 fine, time and money to run concurrent, showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it?
Yes, Judge.
All right, because you waived your right to appeal, because you've agreed to the sentence of 2 years, you do not have the court's permission to appeal. Do you understand?
Yes, Judge.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Judge.
All right, good luck to you.
Thank you, Judge.
You're welcome. All right,
May you be excused, Judge.
yes. We'll see you when we see you.
Thank you, Judge.
You're welcome. All right, so who's the attorney for Diamond? Dan?
They're on their way.
Okay. And then Joe Jimenez.
Oh, Robert Porter said he's on his way.
All right. And then we have Rolando Garza.
That's the one that we're coming back at 1:30, the birthday defendant.
All right, 1:30. All right, so here's the question. Since we're coming back at 1:30 anyway.
But
Oh,
At 1:30 for them.
You don't need to.
I may not need you back, Mr. Villarreal, but I think my mom wants you to come back. So when are you officially leaving?
I think this will be at the end of this week.
Okay.
But this is Ruben. You didn't get to meet Ruben yet, did you?
No, I didn't meet Ruben. Ruben just came in stealth-like.
So they'll be coming, I think this week essentially is like training you, training here all week.
All right, so what's your full name?
Ruben Herrera.
All right, so just so you know, Michael Villarreal is one of my mom's favorites, so you have a lot to live up to.
I've heard I've got some big. I try my best.
The only person who's higher on the totem pole than Michael is maybe Jason. And of course, Cornelius Cox is always up there.
Well, you know what, she might appreciate the more mature age of those latter two individuals. I'll take that for what it's worth.
And of course, she loves Bo Wood. She's like, Bo is always so happy. Oh, I love Bo. And he and I always share book selections. All right, so
Want to go upstairs to grab something to eat, Judge, and I'll be back.
sure. All right, thank you.
Angelina's not here today.
All
I
right,
can
so
have one.
you can go take your break.
Like how long? I'm
gonna go grab because we just have everyone else is on bond, correct, except for the other person? All right, so actually, we don't need to be on the record for that attorney to review evidence with his client. So that's on Mr. Garza. And Joe Jimenez, they're still working on that for federal trial. So we're not going to need you. All right. Okay, thanks. You're welcome. So it's